The clerk will now proceed to read the orders of the day.
Border Security, Asylum and Immigration Bill as amended in Public Bill Committee to be considered.
Now,
we will begin with Government New Clause 5, with which it will be convenient to consider the other selected new clauses and amendments as listed on the selection paper. I call the Minister to move Government New Clause 5.
Thank you, Madam Deputy Speaker. I beg to move that the clause be read a second time. But before I set out the key government amendments tabled for report, I'd like to recall why the government has brought forward this bill. We are working to take the necessary actions to secure our borders and to bring order to the chaotic immigration and asylum system which we inherited, to go after the dangerous criminal gangs that undermine our border security, and this legislation is part of that plan for change. For 6 years, the organised gangs behind small boat crossings have been allowed to take hold. So we are strengthening international partnerships, enhancing enforcement operations nationally and internationally, and equipping ourselves with the tools we need to identify, disrupt and dismantle criminal gangs while strengthening the security of our borders. The organised Immigration Crime Summit hosted by this government in London last month mobilised over 40 countries and organisations to launch an unprecedented global fight against the ruthless people smuggling gangs. The new landmark measures in this bill will provide law enforcement agencies working across the border security system with stronger powers to pursue, disrupt and deter organised immigration crime. Of course.
Can I thank the Minister for giving me? Minister, one of the things that I know that I've just asked questions in this chamber before, and to be fair, the Minister has answered in a positive fashion, is the issue of border security in Northern Ireland, where people can come from the Republic of Ireland into Northern Ireland and across the UK. So when it comes to closing the borders, it's so important that the borders with the Republic of Ireland and Northern Ireland are closed. So can I ask the Minister this question? What discussions and in-depth discussions have taken place between the Garda Síochána, the PSNI and the security forces to ensure that that avenue of illegal immigration is closed and closed for good?
Madam Deputy Speaker, as I've done before, I can assure the honourable gentleman that the border security force in this country work very closely with the PSNI and, of course, the Garda Síochána to deal with all of the potential threats in the common travel area. And I can assure him that we keep a very close eye on what's going on there to ensure that the honourable gentleman's worries are properly addressed. This bill strengthens the immigration and asylum system. We're repealing the costly and unworkable legislation introduced by the previous government and introducing new provisions to address the current shortcomings, tackle harm and build a more efficient and robust system. This bill is about making changes to enable a properly functioning immigration and asylum system which ensures that those with a genuine right to be here are properly supported, whilst those who have no right or legal right to remain in the UK do not abuse the system and undermine the protections the UK has a history of providing to those in need. I give way.
I thank the Minister for giving way, and she's given a really important speech about a very important subject. Would she agree with me? Part of the issue with the asylum system is the backlog created by the previous government, who actually decided the best way to deal with this, wrongly decided the best way to deal with this issue was to make the process take longer as some sort of deterrent. But actually that meant that there was a huge backlog that this government has to tackle.
Minister.
Well, my honourable friend is right. We inherited a system in total chaos where asylum decision-making had all but ground to a halt, and many tens of thousands of people were left having claimed asylum, which law allowed them to do, but not being able to be processed because the last government passed a law which made it illegal for them to be processed. So they were left in limbo, just piling up, costing the taxpayer a fortune. And we have had to untangle the situation that we found. Now, I'm happy to give way.
which is most generous with her time, but she will be aware that today over 600 illegal migrants have entered this country. They could get up to all sorts of mischief, commit crimes and maybe even acts of terrorism. So does she agree with me that these young men crossing the Channel should be immediately detained and deported along with the member for Islington?
Minister.
Well, I certainly hope that that kind of comment might be a joke, but I actually wonder whether that kind of arbitrary treatment of people who are in this country, if we came out of the ECHR as he wants, would become the norm for reform. We are a law-abiding government. The Right Honourable Member for Islington has a complete right to his opinions and a complete right to express them from whatever side of the House that he sits, and I've personally worked with him and have a great deal of respect for him. So I'm quite shocked that the Honourable Gentleman thinks that that's an appropriate thing to say in this place. Now, at committee stage, yes.
Thank you. I thank the Minister for giving way, and on a slightly more constructive point. Does the Minister agree that calls for the process to allow asylum seekers to work after they've been in the country for 3 months would allow them to integrate more closely with their communities, would allow them to earn money to support themselves? Such a measure to change it from 12 months to 3 months would make a massive difference to asylum seekers and reduce the bill for hotels and actually allow them to contribute to the community they want to be a part of.
Well, we're going to come to these debates when we get on to debating the new clauses that the Honourable Gentleman is talking about, but we have been clear on this side of the House that the balance between respecting the work visas, which people have to apply to if they're coming to work here, and then allowing, I will in a minute, and then allowing asylum seekers who haven't applied for work to come and work at that sort of length, would risk undermining the system. We have a disagreement about timing. The answer to the Honourable Gentleman's question is that at the moment you can work if you're an asylum seeker and your case hasn't been heard after 12 months if it's through no fault of your own. So we're talking about time here, but I think the balance between not undermining our work visa system and having a pull factor for more people to come across illegally is the one that we're talking about here. I give way to the Right Honourable Gentleman.
I thank the Minister for giving way and thank you for the remarks she just made. Would she accept that people that make an incredibly dangerous journey and are exploited in doing so are often totally desperate, are victims of human rights abuse and war, have been through horrendous journeys to get there, and one day they'll find somewhere to live where they'll be able to live their lives and make a contribution to our society? Don't we as a world need to look at the plight of refugees as a whole and do much more about trying to bring an end to the conditions that force people to seek those desperate journeys in the first place?
I agree with the Right Honourable Gentleman that we have to always think about the humanity involved in here and not try to label everybody who comes into our country when they're claiming asylum as some kind of threat or even worse as a terrorist, something that's just been said from the benches opposite. We have to treat every case on its merits and we have to treat every person as an individual human being, but we also have to recognise, and the Right Honourable Gentleman needs to recognise this too, that not everybody who comes across in a boat is the kind of person he describes. Some of them are actually the people running the people smuggling gangs. So there's a variety of humanity that comes across on the boats, like there's a variety of humanity that one can discover if one comes across a pool of human beings everywhere. Now, I wish to get on with actually moving the amendments, but because I served with him on the ISA, I'm going to give way to the Right Honourable.
I'm grateful to the Right Honourable Lady for giving way. Isn't the truth of the matter that showing humanity means recognising, as she's implied, that some of the people are coming, perfectly understandably, for entirely economic reasons? If you thought you could get a better deal in Britain for you and your family, you turn up and say you were claiming asylum on all kinds of grounds. And that's the real truth of it. The system is being gamed, and it has to stop being gamed.
Minister.
Yes, in some circumstances, no in others, because some people who come over are genuine asylum seekers, and even under the Right Honourable Gentleman's government, when he was indeed in the Home Office too, they were granted asylum. So, as always, there are many, many different circumstances, and each one has to be looked at and judged on its merits. I'm now going to get on. I'm sorry, I need to get on because we don't have a lot of time, and I think I've been generous. The Government has tabled further amendments, which I now wish to turn to strengthen the current bill. Firstly, new clause 5, which extends right-to-work checks. Preventing illegal working forms a critical part of the Government's plan to strengthen the immigration system, restoring tough enforcement of the rules, undermining the proposition sold by unscrupulous criminal gangs that individuals can work in the UK. In reality, such work is illegal and puts individuals into a vulnerable position at risk of exploitation. Legitimate businesses are undercut and the wages of lawful workers are negatively impacted, with links to other labour market abuse, such as tax evasion, breach of the national minimum wage and exploitative working conditions. Those working illegally in the UK are exploiting a loophole in the existing right-to-work scheme, whereby only those organisations who engage individuals under a contract of employment are required to carry out right-to-work checks. Government New Clause 5 means that those who engage individuals to work as casual or temporary workers under a workers' contract, or individual subcontractors and online matching services that provide details of service providers to carry out work or services for potential clients or customers for remuneration will be legally required to check a person's right to work. Individuals who are self-employed in the traditional sense and who contract directly with clients will not be in scope of New Clause 5, ensuring that a member of the public directly engaging a tradesperson or business will not have to carry out a right-to-work check. This is a long overdue extension of right-to-work checks to include sectors which were previously out of scope and crack down on the unscrupulous exploitation of employment law loopholes. I note the amendments for the Honourable Member for Leeds Central and Headingley and the Honourable Member for Hazel Grove relating to the Government's policy on the right to work for asylum seekers, but it's important, as I said earlier, to distinguish those who need protection and those seeking to come here from work. Also that while pull factors for the UK are complex, the perception of easy access to the labour market is among the reasons why people take dangerous journeys to the UK. I now move to a government new clauses 6 and 7. Firstly, asylum appeals in the first-tier tribunal of the Immigration and Asylum Chamber currently take an average of nearly 50 weeks, according to the latest published statistics, and that is because of the huge backlogs that we inherited when we came into government. Government New Clause 6 and 7 seek to set a 24-week statutory time frame requiring the first-tier tribunal of the Immigration and Asylum Chamber to decide both supported accommodation cases and non-detained foreign national offenders within 24 weeks from the date the appeal is lodged, as far as is reasonably practicable. Madam Deputy Speaker, there are no easy or perfect choices here, but the Government has to take action, and we're focusing in the first instance on measures which will allow us to get people out of costly hotels and also facilitate the swifter deportation of non-detained foreign national offenders where it's in the public interest to deport these individuals. Whilst implementing the 24-week time frame for supported asylum appeals and appeals from non-detained foreign national offenders, it's our expectation the judiciary will continue to prioritise appeals lodged by detained foreign national offenders and the most vulnerable. We're working at pace in the Home Office and with the Ministry of Justice and His Majesty's Courts and Tribunal Service to look at all possible improvements to the end-to-end immigration and appeals system and improve the speed and efficiency of decision-making and appeals while continuing to guarantee access to justice. We will set out further reforms to the asylum system later this summer.
The Minister will know that I chair the APPG for freedom of religious belief, and one of the important things for us is those of a Christian faith and other faiths who come here, and government has been incredibly generous to give them the opportunity of asylum and positions here, and the schemes they've had in the past, both the previous government and this government, are to be commended, and I thank them for that. Can the Minister today ensure this House, ensure the people that I represent here in this United Kingdom, but also those from overseas, that the opportunity for those who are persecuted because of their faith can come here as an opportunity for asylum?
Minister.
None of these changes that I've just been talking about in the new clauses will impinge at all on the criteria that are currently used to determine whether somebody has a need for protection under the Refugee Convention, and clearly that does sometimes, in certain circumstances, include the reality of religious persecution in the homeland. So I hope that reassures the honourable gentleman. Government New Clause 8 redefines how the UK interprets the phrase particularly serious crime for the purpose of excluding refugees from the protection against refoulement. Under existing arrangements, anyone convicted of any offence which attracts a custodial sentence of 12 months or more will have committed a particularly serious crime for these purposes. Those arrangements remain unchanged as a result of this amendment. New Clause 8, however, goes further, and it will mean that a particularly serious crime will now include individuals who've received a conviction for a sexual offence listed in Schedule 3 of the Sexual Offences Act 2003. Importantly for these cases, the fact that particularly serious crime has been committed will be a presumption that can obviously be rebutted by the individual in question, so they get a fair hearing. Schedule 3 lists the offences that automatically make an offender subject to notification requirements, meaning that they have to notify personal details to the police annually or whenever their details change. Failure to do so is a criminal offence. This system is sometimes known as the Sex Offenders Register. The government recognises the devastating impact of sexual violence on victims and our communities, and are fully committed to tackling sexual offences and halving violence against women and girls in a decade. To achieve this, a broad set of the right powers must be available for authorities to tackle sexual crimes, bring perpetrators to justice and manage sex offenders. As part of this effort,
as the Minister, and I obviously accept the wisdom behind that new clause, but will the Minister go further and comment on new clause 39 in the name of my right honourable friend, the member for Gainsborough, because that is designed to put an end to another mischief affecting the non-refoulement rules, and that would ensure that there was primacy given to the Torture Convention and the Refugee Convention, and it wasn't possible for the European Court of Human Rights to interpret the Convention in such a way as to exclude those provisions.
Well, I commend the honourable gentleman for his creativity in asking that question when I'm talking about this particular government amendment. I think we had a debate in committee on the Father of the House's amendment, and I certainly intend to come to it later in our proceedings, hopefully when he's here himself. I wanted to say that as part of our efforts to halve violence against women and girls, it's important that the small number of asylum seekers and refugees who've been convicted of particularly serious crimes do not benefit from protection status. Not only have they failed to respect the laws of the UK by committing sexual crimes, but they've also undermined public confidence in the system. This clause changes the law to deny refugee status to those convicted of the abhorrent crimes listed in Schedule 3 of the 2003 Sexual Offences Act, treating them with the seriousness they deserve and supporting our wider mission to halve violence against women and girls in a decade.
I'm very grateful for giving way. She's being very generous. The trouble is, when the judiciary get hold of this and there's an appeal, very often they cite exceptional circumstances, which is cited in the original legislation, but has been interpreted over the years in a very liberal way
so much as to be more or less meaningless. Will the Minister define what exceptional circumstances are more clearly, so there can be no doubt in the minds of lawyers about who might be eligible for appeal against decisions made by the Home Office and who are not?
Minister.
Well, certainly we'll come into the detail of how this works once it's on the statute book in guidance that is issued, but I'm being very clear to the House tonight that the Government wishes to include those few people, the small number of asylum seekers and refugees who've been convicted of serious sexual offences such that they've been put on the sexual offenders register, to be denied refugee status. We will also deny refugee status where we're able to show that an individual has been convicted in a foreign court for a crime that would have fallen under Schedule 3 if they'd been convicted in the UK. Those convicted and made subject to the notification requirements have committed the most serious of sexual offences, which should be included in the definition of a particularly serious crime. And I move on to the Immigration Service Commissioner's changes, which are put down as amendments. The Government is seeking new powers for the Immigration Advice Authority to tamp down on malpractice with the provision of immigration advice. Building on Clause 40, Schedule 1 of the Bill, these new measures will extend the powers of the Immigration Services Commissioner to ensure effective modern regulation and enforcement of immigration advice and services. Government Amendment 24 creates the power to amend the definition of relevant matters, the different types of immigration advice which can be brought in and out of Immigration Services Commissioner's regulatory oversight. This will introduce greater flexibility to keep pace with wider modernisation and transformation of the immigration system. Currently, those definitions are in primary legislation. This moves them into secondary legislation. Government Amendment 25 allows for a person's registration as a provider of immigration advice or immigration services to be cancelled or suspended with immediate effect where serious concerns are raised regarding their actions or behaviour. Government Amendment 26 establishes that persons who have received certain severe disciplinary sanctions cannot continue to provide immigration advice under the supervision of a person regulated by the Immigration and Asylum Act, otherwise known as substitution. Government Amendment 27 introduces additional sanctions, specifically monetary penalties and the ability to amend the amount of the fines, enhancing the range of tools available to the Commissioner to tackle inappropriate or unlawful practice by unregistered advisers and to shore up standards. Monetary penalties may be imposed up to a maximum of £15,000 on its regulated organisations that have breached the Commissioner's codes of standards, obstructed an inspection or failed to comply with regulations. Government Amendment 28 provides the Home Secretary with the power to specify a non-exhaustive list of fees that the Immigration Service Commissioner can charge for the exercise of its regulatory functions. Having the ability to charge for services such as competence assessments and training will enable the Immigration Services Commissioner to provide more of these services, helping to drive up competence, capability and capacity in the sector. And finally, Government Amendment 29 makes a provision to expand the existing complaints scheme to include unregulated advisers and organisations and to create a civil recovery scheme where the Immigration Services Commissioner can order the refund of fees or the repayment of compensation to the victims of poor practice. The final government amendments relate to the serious crime prevention orders and electronic devices. To support operational efficiency, Government Amendments 6 to 11 will enable an inspector to authorise a constable to use the powers to access, examine, copy, retain or use information under clauses 20, 21 and 23 of the Bill. This is thought to be more operationally effective than the current situation in the Bill, which places that at a superintendent level, as I'm sure the honourable gentleman will remember from our long discourse on these matters in committee. Moving to... yes?
Does she find it strange that in a bill that is so important to Reform UK, indeed it's their raison d'etre, that 80% of Reform UK MPs have left the chamber and are presumably in the pub?
Well, I think they probably call that campaigning, but it's up to them to justify how long they spend in the pub, or indeed in this chamber. Moving to serious crime prevention orders and interim serious crime prevention orders, Government Amendments 14 to 19 will remove Scotland and Northern Ireland from Clause 48, which allows electronic monitoring as a condition of serious crime prevention orders and interim serious crime prevention orders in terrorism-related cases, ensuring that the devolved governments retain full legislative competence over their existing electronic monitoring regimes. For now, I recommend all these government amendments to the House, and I look forward to contributions from other honourable and right honourable members on this gargantuan group of amendments that we're dealing with tonight.
Extension of prohibition on employment to other working arrangements.
The question is that Government New Clause 5 be read a second time. I call Shadow Minister Philp.
Thank you, Madam Deputy Speaker. I rise to move New Clause 14, New Clause 18, and speak to various other new clauses and amendments that stand in my name and those of my honourable and right honourable friends. Madam Deputy Speaker, let me start by just thanking and paying tribute to my honourable friend, the members for the Weald of Kent and Stockton West, sitting beside me here, who toiled with enormous fortitude and patience through, I think, 12 or 18 sessions in committee. They did extremely diligent and good work, and I would like to put on record my thanks to them both. Madam Deputy Speaker, the new clauses and the amendments that I'm moving this evening are made necessary by the government's abject and appalling failure to control small boats crossing the English Channel since they came to office last July. They came to office saying that they would smash the gangs, a claim that is now in tatters. Let's just take a look at what they've done since July the 4th last year. 35,048 people, 35,048 people have illegally crossed the English Channel since the last election. That is a 29% increase on the same period the previous year. This year so far, 2025, how is smashing the gangs going? Well, 11,806 people have crossed, which is the worst start to a year ever in history. That is an appalling and abject failure for which this government is responsible. Just yesterday alone, 232 people crossed, and we understand that today, as we stand here, several hundred more people have made that illegal crossing. There's no control over who they are. There are suggestions that some of the suspects in the recent Iranian terror case were accommodated in asylum accommodation and may potentially, therefore, have crossed by small boat. I certainly recall that some people crossing the Channel had some very serious prior convictions. The government has no idea who they are, and they've certainly got no control. The people crossing are almost entirely young men. They have pushed themselves to the front of the queue by paying people smugglers. I do not see them as victims. They are committing a criminal offence by entering the United Kingdom in this way. It's a criminal offence contrary to Section 24 of the 1971 Immigration Act, as I'm sure everybody knows. But if the former Leader of the Democrats would like to say something to the contrary, I'd be glad to give way.
I'm sorry thank you for giving way. I just couldn't help myself, I'm afraid. 87% of Eritreans coming over are refugees. He talks about young men. They are young men because Christian young men in Eritrea are conscripted to murder their own communities. So, of course, they're disproportionately listed amongst them. Why does he not take part in this debate on the basis of evidence rather than playing tabloid nonsense?
I think the honourable gentleman, the right honourable gentleman, will know that there are very many female refugees around the world, very many children around the world. Indeed, the last government welcomed many of them here under the UK resettlement scheme from Syria. But the young men who push themselves to the way of the front of the queue in Calais are displacing potentially more deserving applicants. And I would just one moment, I will. And I would add that they are embarking from France. Now, France is a manifestly safe country. France is a country with a well-functioning asylum system. Nobody Nobody, including young men from Eritrea, need to leave France to seek sanctuary when they can perfectly well claim asylum in France itself. Indeed, Article 31 of the Refugee Convention, which in general terms prohibits the criminalisation of refugees, expressly says that only applies if someone comes, and I quote, directly from a place of danger. France is not a place of danger. Much better that we choose, I'll give way just in a minute, much better that we choose the deserving cases rather than having people pay criminal gangs to enter this country illegally from a place, namely France, which is anyway safe. I'll give way.
I'm grateful to the Shadow Secretary for giving way. One important point is verification. This government brought forward, the last government brought forward the idea of having verification, which is really, really important. Age verification, because we know that the evidence supports that some young men will claim to be younger than they actually are. Many other countries will use age verification systems from a medical perspective. Does he have a reason why the government has decided not to take those amendments forward in committee, and why they're not considering implementing them at the moment?
Well, I think my honourable friend raises an excellent point. In fact, he draws me to new clause 12, which we have tabled, which essentially mandates the government to get on with implementing scientific age assessments. These are assessments that essentially scientifically verify if someone is or is not over the age of 18. Every other European country uses these tests. It could be things, for example, like an X-ray of the wrist. There are more complicated techniques these days, such as testing DNA methylation, and there are other tests as well which are less intrusive. We're the only country not to use them, and many people who illegally cross the channel claim to be under 18. They usually claim to be 17, when very often common sense would suggest they're actually far older. There have been cases where men with beards have ended up in schools with teenage girls. So I would just ask the documented cases. So I would just ask the Minister, perhaps when she sums up, I'm going to give way over there in a second. I would just ask the Minister, when she replies, to explain to the House what her plans are for introducing these tests. We are an outlier in Europe. We're the only country not to use them. And it would actually, I think, be important from a safeguarding perspective to make sure that people who claim to be, for example, 17, really are 17 and not in their mid-20s. Now, the member over there was very keen to intervene, and I think enthusiasm deserves its reward.
Minister, for your condescending tone after your deluded rant in the House. I must say, of course, I must say to the Shadow Minister that you are misleading the House. 400 crossed. 400 crossed in 2018. Over 150,000 crossed since. That's the majority of which were on the watch of the Conservative government. So how they can claim that this on Labour's watch is beyond me. And as the new expert...
I think the honourable gentleman's had long enough for his very short and brief intervention. Shadow Home Secretary.
Thank you, Mo. Well, I certainly agree he's had long enough. Look, I gave his constituents may well agree in a few years' time. I gave the figures very clearly. Since the election, 35,000. That is a 29% increase on the same period a year before. And so far this year, 2025, it has been the worst year on record, the worst year in history for illegal channel crossings. The claims to smash the gangs lie in tatters. Now, there was a... Yeah, of course.
Honourable gentleman for giving way, and we missed him in the committee. But I wonder if he would explain, given the sophistication of the organised immigration crime threat to the country, why he's planning on voting against the bill tonight when the bill provides counter-terrorism style powers which the National Crime Agency and our security services have told us that they want to be able to bring to bear on this serious question.
Yeah. Well, I must say I missed being there as well, and I did miss the prospect of spending hours and hours in the Honourable Lady's company. Perhaps on some other occasion an opportunity will present itself. But on her question about the bill, she's inviting me to comment on really a third reading matter, but since she asked the question, When you vote on a bill at third reading, a yes or no vote, you're voting on the bill in its totality. Now, while the counter-terror measures may have a very marginal benefit, and it will be no more than marginal, as she should know, this bill also does some extremely damaging things that will make it actually a lot harder to control our borders. One of the things it does, for example, is it repeals pretty much the entirety of the Illegal Immigration Act. Clause 38 of the bill does that. Now the Illegal Immigration Act requires the I'm going to just answer the question, if it's okay. The Illegal Immigration Act, amongst other things, requires the government to remove people who arrive here illegally. Amongst other things, the Illegal Immigration Act says there is no path to citizenship for somebody who comes to this country illegally, a very sensible measure. This bill before us repeals almost all of that. But secondly, the other thing this bill does is it removes from the statute books the legislative basis to implement a removals deterrent. Now, one of the first things this government did when it came to office was it cancelled the Rwanda scheme before... Now, I'm going to just answer the question first. It cancelled the Rwanda scheme before it even started. The first flight had been due to take off on the 24th of July. Now, everybody has warned, the National Crime Agency warned, that without a removals deterrent, you're not going to stop the boats. Law enforcement alone, important though it is not enough. A border security commander with no powers is certainly not enough. Experience around the world says you need a removals deterrent. That is to say, if somebody enters the UK illegally from France, if they are rapidly removed somewhere else, be it Rwanda or elsewhere, they're not going to attempt the crossing, knowing removal will follow. Now, Australia tried something very similar about 10 years ago. They called it Operation Sovereign Borders. They, in fact, had a bigger problem than we did. There were 50,000 people a year crossing at that time. And within a very short space of time, a few months, the removals deterrent they used stopped those illegal maritime arrivals, as they called it, entirely, went to zero, and it saved lives in the process as well. Now, Australia used an island called Nauru rather than Rwanda, but the principle is the same. And the decision, I mean, the Home Office ministers must by now be regretting their hastiness, because in the absence of any removal deterrent, the numbers have gone through the roof. And as I said already, this year so far has been the worst on history. Without a removals deterrent, there is no hope of stopping these crossings. And one of the other things this bill does, in Clause 37, is it repeals the entirety of the Safety of Rwanda Act. That is why our Amendment 32 seeks to reinstate that clause, because there will probably come a time, if not today, then in 6 months, and if not in 6 months, then in 12 months, then these Labour ministers will realise their plans are not working, the numbers are getting worse, and without a removals deterrent, they are not going to stop the boats. And that is why this bill is so misguided, it's why their policy is so misguided, and it's why the numbers this year have been the worst in history. Give way over there.
Thank you very much. Could the Shadow Minister comment on the views of his colleague, the member for Stockton West, when he said during the Borders Committee, immigration is too high, previous governments have failed to solve it? And also, could he comment on the member for Weald of Kent, when she said in the same committee, the system is broken, it has been broken for many decades, and that is now plain to see?
Yeah, I do agree with both my colleagues, and that is why we are tabling amendments and new clauses today which will address this issue. And I'll come on to talk about some of those new clauses in just a moment. But, Madam Deputy Speaker, it was the Labour government that chose to cancel the deterrent before it started, and that is why the numbers are higher than they have ever been in history. It's a result of their choices. Now, Madam Deputy Speaker, let me move on to the provisions on indefinite leave to remain. I'll give way.
I thank the Shadow Minister for giving way. I'm talking of the Rwanda scheme. The previous Tory government spent £700 million on a scheme that had 4 volunteers that were moved. This included £290 million given to Rwanda for nothing in return, and £134 million on IT systems that were never used. Can we get a refund?
Well, the plan was, as I said already, the plan was never started. The first plane was due to take off on the 24th of July, but the Labour government cancelled it within days of coming to office. That money would have been extremely well spent had the scheme started, because the deterrent effect would have stopped the boats, and that would have meant we don't have tens of thousands of people in hotels costing billions and billions. And in fact, while we're on the topic of hotels, let's have a look at the Labour government's pledge to end the use of asylum hotels during the election. How's that pledge going? Well, the numbers in asylum hotels have gone up by 8,000 so far under this Labour government. And in fact, speaking also of removals deterrents, I was in Berlin probably 4 or 5 weeks ago talking to members of the CDU who are now obviously in government, and the incoming German government intends to implement a removals deterrent very similar in concept to the Rwanda scheme. So other governments around the world have realised you've got to do this. It worked in Australia. The new German government are going to be doing something very similar. It's just our government going headlong in the opposite direction. Now, I'm going to make some progress. Now, Madam Deputy Speaker, I'm just going to speak for a moment to the clauses on ILR, indefinite leave to remain, and in particular, new clause 11, which sets a limit for eligibility for ILR to 10 years, and new clause 17, which sets various conditions on ILR, essentially saying that to get ILR after 10 years, you have to have made a sort of economic contribution. You can't be a burden on other taxpayers. Now, those strike me as very fair. Now, I notice in the immigration announcement by the Prime Minister this morning, he made reference to 10 years ILR, despite the fact the Honourable Lady and her colleagues voted against that measure just a few weeks ago. I wonder what has magically changed their minds. But if they are serious about this, will they be supporting new clause 11, which implements what the Prime Minister announced this morning? Will they be voting for that later on? But if I understand the Prime Minister's announcement correctly, he was saying, the Prime Minister was saying, that when someone reaches 10 years residence, they automatically qualify for ILR, indefinite leave to remain, under the government's proposals. But what we're saying in our new clause 17 is that there should be conditionality even after 10 years. The person should be making some kind of contribution to the country in order to qualify for indefinite leave to remain. So would she take the opportunity to agree with that approach, and would she therefore support new clause 17 that we have tabled to this bill? Now, Madam Deputy Speaker, let me turn to the two new clauses that we intend to move to a vote this evening. And the first of those is new clause 18, to be found on page 18 of the amendment paper. This establishes a binding cap on immigration numbers each year, a cap that would be voted on in this Parliament, democratically accountable and completely transparent. Of course, it would be up to Parliament to debate what that number should be, but I would be arguing it should be a lot lower than any recent number we've seen, and indeed a lot lower than the recent forecasts we've seen from the ONS and the OBR. But the critical point, let me just finish the point, but the critical point, whatever your views on the number are, is that it would be this Parliament every year that voted to cap migration. So never again would we see immigration rise to levels far higher than anyone intended. We wouldn't ever again see unintended consequences where visa rules are set up, but it turns out the numbers are much higher. A good example of that is the health and social care visa, which was initially only supposed to be a few thousand people, but ended up being hundreds of thousands. With a cap mechanism in place, that would never happen again. So I invite the Minister in her response to tell me, will she support a binding annual cap decided by this Parliament? Will she support democratic accountability for that number? And if not, why on earth wouldn't she? Because I can't see any reason at all why this elected Parliament shouldn't set the limit each and every year, rather than having numbers that many of us would think are far too high.
I thank him I thank the honourable gentleman for giving way. He's speaking with great confidence, as ever. And and volume, I have to say. So you're very clear. Sorry, the honourable gentleman is very clear about the cap. Very clear. But what's less clear is what level he believes it should be set at. He said it should be lower than the current numbers, but with his experience and confidence, what level does he feel it should be set at? What would his first proposal be for that cap?
Well, I'll tell you what, how about he votes for the cap this evening, and then we'll have the debate about what level the cap should be at. We're not going to be debating the level of it when it currently doesn't even exist, and his own front bench are trying to deny him a voice on this issue and deny every single member in this House a voice on this issue. If you believe in Parliament deciding these things, if you believe in democratic accountability, members opposite will vote for new clause 18 this evening and let Parliament decide what that cap should be.
Thank you. I think the cap idea builds on some of the work the last government was wanting to bring forward about refugees and asylum seekers when it was asking councils to work up how many they could accommodate. That seems remarkably practical to say that we are a generous nation to be able to look after those people in need, but it comes with the capacity. The whole idea would be to implement a cap then that has all councils in England, Wales, Scotland and Northern Ireland be able to say what they could hold and us vote on it as a nation. Is that something that he would consider under this idea of a cap when it comes to dealing with asylum seekers?
Well, I think my honourable friend makes a good point. And actually it's germane to the earlier discussion about people crossing the Channel illegally, because so long as we have, so far 11,000, 12,000 this year crossing the Channel, worst year ever, it makes it very difficult to accommodate or create safe and legal routes, because our capacity is completely taken up by those people entering the country illegally. If we can stop illegal migration using the measures I've suggested, particularly a removals deterrent, it will then create capacity to have a limited, safe and legal route for people who we, the government, Parliament, judge to be deserving, as we did with the Syria crisis, where the UK resettlement scheme went to refugee camps on the Syrian borders and identified the most vulnerable refugees, very often women and children, and brought them to the UK instead of people crossing the Channel illegally, pushing their way to the front of the queue. It is exactly this approach, new approach, that a tougher approach on illegal immigration would facilitate. I'm just going to make a little bit of progress. Now, Madam Deputy Speaker, the second amendment that we intend to put to a vote this evening concerns the Human Rights Act. Now, the government, the Home Secretary in her statement earlier, and the Shadow Minister in her remarks the Minister in her remarks a few moments ago talked about tinkering with Article 8. But the truth is that will not really make any meaningful difference. Now, it's worth just reminding ourselves what the history of this is. The ECHR, a treaty, international treaty, we entered into, indeed helped draft, in 1950. In 1998, the Blair government passed the Human Rights Act. And what the Human Rights Act did was essentially incorporated the ECHR into domestic law, which means essentially that UK courts, when making any decision, immigration decisions or indeed any other decision, can use their interpretation of the ECHR to interpret legislation passed by this House, but also injunct the government, prevent the government from taking a particular executive action, which might include, for example, removing or deporting someone. Now, the problem, so essentially empowered UK judges to use the ECHR however they saw fit. Now, the problem with the ECHR as drafted is that unlike a piece of domestic legislation, like the one we're looking at today, which is very detailed, everything is very sort of precisely defined, the ECHR isn't like that. It's very sort of vaguely worded. For example, Article 3, freedom from torture, inhuman and degrading treatment, or Article 8, the right to a private and family life. Now, nothing objectionable about those in themselves, but the problem is that over the years, judges have expanded their interpretation of those in ever more extraordinary ways that frankly defy common sense. And let me just give the House an example of one or two of those judgments. For example, there was a paedophile of Zimbabwean nationality who fell for deportation under Section 32 of the 2007 Borders Act. Quite rightly, he should have been deported. But a judge said no. A judge said no. Under their interpretation of the East, this is a UK judge, not Strasbourg, UK judge, they said this convicted paedophile might face some hostility if they were returned to Zimbabwe in a manner which breached their Article 3, not Article 8, Article 3 rights. And so the judge said, this convicted paedophile can stay here in the UK. Well, my question is this. What about the human rights of British children to be protected from paedophiles like that? What about the rights of British citizens to be protected from foreign offenders? There was another case, an Iraqi drug dealer who fell for deportation, rightly, back to Iraq, but a judge found that he had become, quotes, too westernised and therefore couldn't be returned to Iraq, his country of nationality and country of origin. Those are just two examples of thousands and thousands of examples where domestic UK judges have stretched the definition of ECHR articles in a way that defies all common sense and certainly, and let me finish the point, and certainly goes far, far beyond anything the original framers of the ECHR had in mind when they signed up to it in 1950. And that is why As a first step, we propose to essentially repeal the Human Rights Act in relation to all immigration matters. And what that means is that domestic UK judges will no longer be able to apply their own creative and expansive interpretations of the ECHR when making immigration decisions. Instead, they will have to have regard solely and exclusively to domestic legislation that we have passed in this House. That strikes me as a common-sense measure that would end these ridiculous judgments being handed down and would enable the government to ensure that people with no right to be here and dangerous foreign criminals could in fact be removed, whereas at the moment judges are preventing that using interpretations that would completely defy common sense. Last time.
I thank the honourable member for giving way. In his statement, he is very clearly concerned about child protection. So, did he read the testimony of the Children's Commissioner who talked about the children who made their way to our country and who went missing into the system? Victims of rape, sexual abuse, exploitation, some of the most horrendous things that can happen, people who have gone missing. Does he regret the role of his government in facilitating such abuse?
Where that time is running on. Shadow Home Secretary.
Well, I mean, the Deputy Speaker has said I need to wind up. Of course, we need to pay attention to the rights and protection of children, but having people being smuggled across the English Channel on boats does not in any way help with child protection issues. Madam Deputy Speaker, I will of course follow your injunction to wind up. If the government is serious about getting back control of the immigration system and stopping illegal immigration, they will support our measures this evening. They'll support a cap on migration and they will support the repeal of the Human Rights Act in relation to immigration matters.
We will start with an immediate 4-minute time limit on, with the exception of front bench speeches and also any maiden speeches this evening. I call Kim Johnson.
Thank you, Madam Deputy Speaker. The Bill's intention to repeal much of the Illegal Migration Act is extremely welcome, particularly the scrapping of the Rwanda scheme. Years of brutal Tory policies that criminalise, persecute and scapegoat migrants and those seeking safety on our shores must be unravelled by this Labour government. But we must go further and faster and turn our backs entirely on the politics of hate and division if we are to avoid future repeats of the recent election results. The recent riots that took place in my city last year that targeted asylum, accommodation and organisations and visibly black people and businesses did not emerge from nowhere. They were the result of the myths and misinformation that perpetrated media and social media. For our Prime Minister to say today that unfettered immigration risks the UK becoming an island of strangers is deeply concerning to me. We cannot concede to the anti-migrant agenda promoted by those who thrive on division. It is simply dishonest to suggest that migration causes falling living standards. It's not migrants, it's political decisions that have hollowed out our communities, brought public service to its knees and allowed inequality to run rampant. And I'm proud of my African and Irish heritage. I'm proud of my home, Liverpool, as being a city of sanctuary. However, I'm not proud of some of the language that's being used today, particularly in terms of the island of strangers, echoing devices and cruel politics of our past. And I've had constituents today say that's very reminiscent of the Rivers of Blood speech. But mine is a port city with people arriving from all over the globe. They are neighbours and friends, and our city is far better for it. And Liverpool has a world-leading HE sector with thousands of international students wanting to train here. And I've spoken to the Vice-Chancellors of Hope University and Liverpool John Moores University, who are both very concerned of these announcements being made today. The Labour government must make the unequivocal case that the fight against racism and scapegoating is the same fight as the one against low pay, poor housing and crumbling public services. You cannot defeat one without the other. While this bill goes some way toward repairing the damage done by the previous government, the overall approach remains punitive. In particular, clause 41 that expands the Home Office's power of detention retrospectively, and the new criminal offences in parts 1 and 2 are deeply concerning, as well as the retention of section 29 of the Illegal Migration Act that removes protections for victims of modern slavery, and section 59 of the same act that makes asylum and human rights claims from a list of countries inadmissible. Instead, we should be focusing on restoring the right to seek asylum in the UK, opening up safe routes, abandoning offshore processing, resolving the legal aid crisis, and restoring the right to work, increasing support rates for asylum seekers, and ending the use of immigration detention and the harmful, destructive rhetoric. In short, building a compassionate, rights-based and evidence-led approach to immigration and asylum. I'm proud to have added my name in support of NC1 that would enshrine a duty on the Home Office to publish quarterly statistics and detailed information on deaths in the asylum system and in small boat channel crossings. Currently, we know that lives are being lost, but we don't know how many, making our asylum seeking an outlier. So I would call on the Home Secretary to take on board some of those comments, please.
Tim Farron. I call Lisa Smart.
Very much, Madam Deputy Speaker. I rise to move new clause 21 and others in my name and the name of other honourable members, and I want to put on record my particular thanks to my honourable friends for Woking and Mid Dunbartonshire for the sterling shift they put in on the Bill Committee. We can all agree on the need to stop these perilous channel crossings, but under the Conservatives, safe and legal routes were dismantled, forcing vulnerable people into the hands of criminal gangs. Meanwhile, the asylum system was left to rot, with a staggering backlog growing year after year. Now we have thousands of people stuck in limbo, unable to work, unable to rebuild their lives, unable to contribute to the UK economy, while taxpayers foot the bill for hotel accommodation in communities like mine. Will she give way? With absolute pleasure, I will give way.
Does she accept that, despite what she just said, under the Conservatives in the last term of government, record numbers of people came here through resettlement schemes, which are safe and legal routes?
I'm very grateful to the honourable gentleman for intervening on me in debates regarding immigration, for it is not the first one where we've had a conversation of this nature. Ukrainians came here under the previous government, Hong Kongers came here, and that is to be welcomed. But there are countries in the world where there are no, and Afghans, he makes a valid point. There are countries in the world, Eritrea, Sudan and others, where there are no safe and legal routes, and that is what new clause 21 talks about today. The Home Secretary said in the white paper published this morning that we need an immigration system that is fair and effective, and I strongly agree with her. The current system isn't fair, it isn't effective, and I would have liked to see more in this bill to change that. The Liberal Democrats believe in a common-sense immigration and asylum system that treats people with dignity. That means scrapping headline-chasing gimmicks like the Conservatives' Rwanda plan, investing in swift decision-making and tackling criminal gangs at their roots, and we welcome some of the measures in this bill to those ends. But one of the most glaring injustices of our current system is the ban on work for people seeking asylum. Right now, if you've been waiting months and months for a decision, you're barred from working to support yourself, your family and contribute to the economy. This is wasteful, it's demoralising and it's lose-lose for everyone. New clause 21, in my name, would change that. It proposes that if someone's been waiting for more than 3 months, they should be able to pay their fair share. I know from those seeking asylum in my own area that these are people who want to pay their own way, who want to contribute skills and taxes, and who want to be part of their local communities. We should not be stopping them. This is about common sense. Giving people the right to work will ease the pressure on public finances and give dignity back to those caught up in the system. It will help employers fill vacancies at a time of work shortages and allow asylum seekers to build the foundations of a new life. Madam Deputy Speaker, I urge colleagues across the House to support this amendment. It's the fair thing to do, it's the practical thing to do, and it benefits us all. And any government serious about tackling the smuggling gangs, and I do believe this one is, must cut off their business model at the source. New clauses 22 and 36 would require the government to set out new, safe and legal routes, giving those fleeing persecution a proper alternative to dangerous crossings. The lack of these routes is a direct cause of the current crisis. We can't keep saying we want to stop the boats while slamming shut every door to safety for those who need it. This must certainly include greater scope for family reunion. No child should have to face the trauma of fleeing war or persecution alone, only to be denied proper contact with their loved ones. New Clause 27 would widen family reunion rules so that unaccompanied child refugees can be joined by their closest relatives.
Would you give way?
I will give way.
I thank my honourable friend for giving way on the point about reuniting families, because the Shadow Minister seemed to be utterly bemused as to why so many migrants and illegal immigrants are male rather than female. And I'm wondering if my friend is aware of the Doctors Without Borders report that showed that a large number of sub-Saharan African women were being injected with such high levels of contraceptive as to make them permanently infertile because they were being raped so many times on their way here that they couldn't then work because they were pregnant to pay off their debt. And actually a fairer system would allow for more women and children to come to the UK.
Very grateful to my honourable friend for the point he raises, and that is one of a number of utterly hideous stories that any of us could find for any of the wonderful organisations and NGOs working with asylum seekers, working with refugees coming to this country. And I'd like to put on record my thanks to my friend from the other place, Baroness Hamwee, has done a huge amount of work looking at family reunification and work in this area. This is about basic humanity. These children need safety and the support of their families to truly rebuild their lives. Madam Deputy Speaker, people smuggling of the type this government is trying to crack down on is an international problem, and we can't solve it by going alone. New clauses 23 to 26 will bolster our cooperation with Europol, engaging regular meetings with their leadership, joint task forces, more resources, and a transparent system of reporting back to Parliament. To dismantle these smuggling networks, we need to be working hand in glove with our European allies. This bill could go further to strengthen those vital ties. The UK should be leading on this, not lagging behind. The Liberal Democrats will keep fighting for a system that is fair, fast and humane, where safe routes are in place, families can be reunited, and those who come here are treated with dignity and can contribute to their new communities. Our amendments offer practical steps to rebuild an asylum system that works for all of us, and I urge the House to back these amendments today for practical, humane and effective solutions.
Vaughan.
Thank you, Madam Deputy Speaker. I draw attention to my register of interest and the support provided to my office by the Refugee, Asylum and Migration Policy Project. I also chair the APPG on refugees. I thank the Ministers and members of the Public Bill Committee for their work on this bill, which I continue to support as a whole. My constituents in Folkestone and Hythe want to see Parliament give our law enforcement agencies the powers that they need to tackle these highly sophisticated organised criminals. The small boats industry, which was allowed under the party opposite to run for years, had flourished in part because of the lack of powers for the NCA and the lack of coordination with our European partners. What we absolutely do not need is a performative politics of the party opposite, like with its amendments to disapply the Human Rights Act in immigration functions with its NC14 amendment. We've just had the VE Day 80th anniversary, and it was that fundamentally important victory over tyranny in Europe which led European democracies uniting to safeguard the rights of everyone living within Europe. When I met Ukrainian politicians at the Council of Europe in January this year, they were very clear that they need human rights, the rule of law, democracy and unity of values in Europe. And they need us, the United Kingdom, to help them in their fight against an enemy that lacks those principles. We're at a point in history when it's more important than ever to be clear about our values, about what makes a society one to be proud of, about what we have in common with our neighbours and friends. Disapplying the Human Rights Act for one group today, maybe the party opposite will want to deprive it from another group tomorrow, is rightly not what the government will do. And the opposition's amendment, which I will oppose, is a reminder of this important dividing line in our politics. I also want to comment on Amendment NC3 on safe and managed routes to seek asylum. This is an issue I raised in the Chamber at second reading. I fully accept that safe routes will not on their own stop small boat crossings, which is why we need the enforcement measures in this bill. But I do not think it's sustainable for it to continue to be virtually impossible to claim asylum lawfully, and then to criminalise those who have made valid claims yet have no lawful means to access the asylum system. I'm grateful to the Minister for Migration and Citizenship for agreeing to meet with me next week to discuss this issue. A recent report by the APPG on refugees proposed a pilot system for those from specific conflict zones who have strong claims to be allowed to travel here, so that their claim can be fully examined on UK soil. That will build an evidence base on the issue to inform future policy making. Finally, in relation to British citizenship, while repealing the bar on citizenship for those arriving unlawfully, the government has effectively reintroduced it via policy. I would ask the government to rethink its approach on this. By the time the person in this situation applies for citizenship, they will have been granted asylum with a well-founded claim. They will have been here for over 5 or 6 years, be entirely of good character, may be making a valued contribution to our society, yet because of their method of entry all those years ago, they could be prevented from accessing citizenship and prevented from integrating into this country. I think we need measures to promote integration of those lawfully present here rather than hinder it. Despite these points, I do say, support this bill and thank the Government and the members for working on it.
I call Tim Farron.
Thank you, Madam Deputy Speaker. I draw members' attention to my entry in the register, including my work with the Refugee, Asylum and Migration Partnership. Our new Clause 21 helps the Government to tackle poverty, prevent homelessness and demonstrate competence. By enabling asylum seekers to work, it will also reduce the asylum support budget because those asylum seekers can instead support themselves. It will help cohesion between host communities and asylum seekers if they are seen to be paying their way. It will reduce the need to use hotels to house asylum seekers. Those seeking asylum should have the dignity of being able to work, and the taxpayer should get the benefit of the massively reduced costs that this would bring. Moving on to new clauses 22 and 35 on safe routes and humanitarian visas. As things stand, desperate people choose unsafe journeys to uncertain destinations delivered by those who care nothing for their welfare and who continue to cash in while people continue to die in terror in the Mediterranean and in the Channel. But for people escaping tragedy and terror in Eritrea, Sudan and elsewhere who have passed through the lawless horror that is Libya and crossed the Mediterranean, the Channel holds fewer fears than it would do for the likes of us. So we need an intervention that will change people's decisions. This amendment suggests a pilot visa scheme to authorise people who meet the criteria to travel to the United Kingdom safely in order to claim asylum. This proposal means a controlled, ordered, planned, dignified and humane process. Now, talk of strangers, of invasions, of swarms of migrants is despicable. The implication that not just refugees but diaspora communities here in the UK are somehow lesser citizens, not really British, is utterly shameful language, and I condemn it. Politicians and commentators who use such language are guilty, frankly, of spending too much time online and too little time on the doorsteps, market squares, even in the pubs, churches and communities. You see, the reason that the Rwanda scheme was so unpopular was not, shockingly, because every Brit is a bleeding heart liberal, but because the scheme was unfair and ineffective. The British people just want fairness and competence. So I urge the government not to fall into the Tory trap of making ludicrous promises they cannot keep, and I counsel other opposition parties not to make ludicrous promises that they wouldn't be able to keep either, because one day you may actually find yourself in power and face the wrath of an electorate for your failure to deliver. So look, in my closing words, in these discussions on migration, I have read and heard far too much about there being references to the apparent threat to Britain's Christian heritage. Well, let me just finish by saying this. The Bible does not tell us what our policy should be, but it definitely tells us what our posture and our attitude should be. And I'm afraid the Prime Minister made awful remarks today about an island of strangers. Leviticus 19 rebukes him, and I quote, "The stranger who resides with you shall be to you like someone native born among you, and you shall love him as yourself." As the socially conservative American theologian Russell Moore says, yes, Jesus was a refugee, and he is still in their camp. We should be also.
I call Stella Creasy.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, I represent Walthamstow. Once upon a time, the architect of the ECHR was the next-door neighbour, Winston Churchill. But let's be under no illusions, let's be frank about it, because people in this chamber will write off my corner of London as some nirvana of good relations, that we don't get the issues or challenges with immigration. We have people in our community who judge people on the basis of their skin colour, who listen to the social media tropes. We have people who seek division, who share a common aim, find somebody to blame rather than a solution for the challenges we face. Legislation needs to be the counter to that, not the facilitator to it. Because the reality is, across this country, there are just too many people with too much month at the end of their money. And it's too easy to tell those people that it's immigrants are the reason why that is the case, rather than the truth. Because the people in my community are not woke, they're wise. They get that trying to tell them that immigrants are the problem when actually it's politicians is the truth. Politicians who don't face up to the challenges that we face. The people in my community, as are people across this country, know whether it's old friends or strangers, incomers from Hackney or even further afield. They can all find common ground if you don't get their bins collected, or if they can't park their cars, or yes, if they feel their children are at risk. Humanity finds each other in this country in our common grumbles. That is what it means to be British, to have a moan about the reality of daily life. And those who want to divide us, those who want to tell us that somehow this is the way forward, find somebody to blame rather than solutions to those challenges, do nobody a service. So let's talk about what we could do in this bill to make things better. Let me support my colleague from across the border in the Victoria line with new clause 37. We shouldn't be making a profit out of children who are seeking to be citizens who have the right to remain here. Let me also draw to the attention the Minister new clause 44 that I have tabled, learning from Australia and New Zealand, those bastions of progressive immigration policy, in introducing a workers' justice visa. Let me be clear, we really need to help the overseas workers in our communities who are at the behest of their sponsors. It is outrageous in this country that there are people whose future relies on somebody else's largesse rather than their basic human rights. But we can learn from Australia and New Zealand in introducing a workers' justice visa to correct that issue, that when there is somebody who is clearly a victim of modern slavery, they can't stay in the country to pursue that claim, so the person who is making them a slave cannot be held to account.
On that point,
I'll have to give way.
I thank my honourable friend for giving way. Does she agree with me that we have got significant problems in this country as the modern slavery system has degraded? And will she join me in trying to push for the NRM to be reviewed, as the government has promised, to tackle exactly what she's talking about?
Absolutely, and let me be clear that I recognise it will not address all the issues with overseas domestic workers, but a workers' justice visa could be the start of making sure that our immigration system is more functional. Let me also draw to the Minister's attention new clause 45, which is about the good character requirement. It makes no sense at all to those of us who are concerned about integration to say to somebody that they may stay in this country. They have a well-founded fear of persecution, but they'll never be able to make a life here. They'll always end up paying more for their mortgages because they won't be able to get a proper income. They'll never be able to get jobs as easily as others, so they might be more dependent on benefits. That is what happens when we start denying citizenship to people who have actually got the right to be here. The Refugee Council recognised that this will affect 71,000 people because it is retrospective. Little wonder there is a court case now in train. Bad policy making in the face of social media tropes does nobody any favours. And I urge the ministers to look again at this, to address how we could deal with it. This amendment is simple. It's about us upholding our international obligations. It's about saying if there was a safe route, absolutely, it is bad character not to use it, but I'd love the members opposite who are no longer in their place to tell me what the safe route from Iran is, when many of the people on the boats are from Iran. We have to get immigration policy right. I stand here as somebody who does not want open borders. I want a fair and just immigration service, who learnt in my first year in this place from the former Home Secretary Jack Straw, who told me there were two divides, left and right, and those people who had to deal with the UKBA and those who didn't. The legislation before us does many welcome things, but it also does things that I fear in future we will come to regret, just as we will come to regret pandering to those people who wish to divide us, rather than getting on and sorting out why it is that we still have a cost of living crisis in this country. The government will have my support if it wants to do more to make sure we can bring people together, not just to sort out bin collections, that perennial challenge, but also to invest in everybody, whether they were born here or they come here to make a contribution. After all, those of us with refugee heritage, whether we were Huguenots, the Farages and the Creasys, deserve need better than less.
Yeah. We'll now start a 3-minute time limit I call Will Forster.
Speaker, my constituency of Woking has a proud and long history of supporting those fleeing persecution. It was home to the Ockenden Venture, a trailblazing charity founded in the 1950s that helped resettle refugees from post-war Europe to Vietnam and beyond. A former MP for Woking, Humphrey Mallons, a Conservative, even set up a national immigration service. That legacy reminds us the best of British values, and especially today I think it's important we reflect on that and what makes Britain great. Yet this bill falls far short of those values, not very great at all. I sat on the Public Bill Committee for this legislation, where I proposed 15 amendments. While I support parts of this bill that seeks to tackle the cruel trade of people smuggling, I'm deeply concerned that once again this government is prioritising punitive headlines over practical solutions. One area in which the bill completely fails is to lift the ban on asylum seekers working whilst they await their decision, and that's why I support new clause 21. People are waiting for years in limbo whilst their application is processed, with no right to contribute, no right to earn, and no hope of building their lives. During the Bill Committee, we heard that as a result of the former Conservative government's mishandling of the situation, 19 people have waited 10 years or more for their claim to be settled. These are capable adults that should have been contributing to the economy. Letting people work is the right thing to do. That's why Australia lets them do it straight away. That's why Canada allows refugees to apply for a work permit while their application is being processed. The United States allows people to work when they're seeking asylum after 6 months. Human beings are amazing creatures. They're capable of so much. It's a waste to keep people essentially kept away from society. We want to support them. That's what New Clause will do. It's the right to let people to work after 3 months. I urge colleagues in this House to support it. I briefly mentioned the safe legal routes. Ukraine has showed us that if we provide safe legal routes, it takes away the people smugglers, it takes away the illegal immigration. That's why I support New Clause 22 and 36 from my party and New Clause 3 from the SNP. These are vital measures that will tackle the root causes of those dangerous crossings. I hope members support both of them. And critically, Interpol was an issue we talked in the Bill Committee. We are turning our back. We're not asking Europe to help us with this problem. The government refused to do so. Instead of isolating ourselves, we should be leading those efforts to tackle smuggling gangs. We cannot solve a global crisis by resolving that without those main issues. But we can do better. That's why Britain's got a proud history, and this bill should be a lot better.
Yeah. I call Olivia Blair.
Speaker, and I'd like to point the House to my declaration in the Registered Member of Interest from the help I received from the Refugee, Asylum, Migration Policy Project, and the fact that I'm the co-chair of the APPG on migration. And I welcome the government action in this bill to repeal parts of the opposition's repeated gimmicks and nonsense legislation that we saw in the last Parliament. But today I wish to speak to New Clause 1, New Clause 2 and New Clause 37, all of which I'm a signatory to. New Clause 1, tabled by my right honourable friend, not right honourable, for Nottingham East, she should be, to require the Home Office to publish quarterly statistics and information on deaths in the asylum system and the small boat channel crossings. Under the last government, a horrifying number of refugees and people seeking asylum had died trying to cross the channel and in Home Office accommodation, with 2024 reaching a record high. And despite the daily, weekly reports of numbers of people stopped or deported, we still don't have regular reporting that is clear and transparent on those that have lost their lives in the system. And that is incredibly important, not just morally, but to address the evidence gap that we have on that, to make sure that we're getting policies right. On New Clause 2, on the report of the right to work, I hear what the Minister was saying about this being a discussion about time. But mental health and working rights are not separate issues. The majority of asylum seekers in the UK are unable to work, and they are unable to use their skills to support themselves and their families, or even to save enough to rent a home. Instead, they are trapped, isolated, inactive and dependent on state support. There are countless compelling reasons why asylum seekers should be allowed to work like the rest of the population, and given the huge amount of support it has from both the public and businesses, we should at least get the opportunity to scrutinise the reasons why this ban remains and the impact it is having. Finally, new clause 37, tabled by my right honourable friend, the member for, again, not right honourable, Clapham and Brixton, on children who are born in the UK, who have grown up here, know no other home, and they're currently priced out of citizenship simply because their parents' immigration status at the time of their birth. These young people are part of our communities, our schools, the fabric of our future. They should not be denied their rights or go on to face barriers in education, housing, healthcare, or across society. These children are not strangers, they are our friends and our neighbours. Some have stoked racist divisions against migrants, a drum that the far right have continually banged since, and that is the rhetoric that this whole House must continually oppose. Amid rising anti-refugee sentiment, including last year's shocking riots, enabling people to feel secure and contribute to their communities could not be more urgent or valuable. I'm aghast by some of the amendments from parties opposite. I wonder how many lives need to be ruined before they will consider it too many. And it is shameful to see this victimisation of those who have come here and tried to find safety, particularly new clause 41.
I call Sarah Pochin to make her maiden speech.
Thank you, Madam Deputy Speaker. And can I start by saying how delighted I am that my colleagues have dragged themselves out of the pub to actually join me for my maiden speech. I'm so proud to be here in this place. I feel so privileged to be here in this place. And I hope that I will make a good contribution to the business of this place with my background as 20 years in public service as both a magistrate and a borough councillor. I would like to thank the voters of Runcorn and Helsby who have put their trust in me. It certainly was a historic night, a night I will never forget. We had a recount at about 3 o'clock in the morning, and the result finally came through at about 6 o'clock in the morning, and there were 6 votes in it. So I think 6 is probably my lucky number from now on.
5 too many.
We certainly put Runcorn and Helsby on the map, and it is actually the closest by-election parliamentary result ever. So lots of drama, made for some great headlines the next day. Well, great headlines for us anyway. I would like to thank and pay tribute to my predecessor, Mike Amesbury. In 2020, he won a ballot to put forward a bill of his choice, and he chose to focus on the cost of living crisis by limiting the cost of school uniforms. This gathered cross-party support, and it went through as an Act of Parliament in 2021. I will also be focusing on the cost of living because it's something that was raised endlessly with me on the doorsteps during the campaign period. Voters that feel let down by this government, voters who have lost their winter fuel allowance, had their disability benefits slashed, have seen their costs of their energy bills go through the roof when they were promised they would go down. It's very important that I make this maiden speech today. There were a few raised eyebrows. I've only been here, well, in fact, less than a week. But this bill is important because it's so relevant to what I believe in. In Runcorn, there are over 900 illegal immigrants that we know about. They are housed both in an asylum hotel, the Daresbury Hotel, which has about 400 illegal immigrants in it, and incidentally, that was to be shut down during the election campaign by the government, but of course is still open. The remaining 500 or so are housed in houses of multiple occupancy, HMOs, in the community. The recent government announcement encouraging private landlords to give up their properties to house illegal immigrants in order to get a 5-year guarantee of rent, to get all the maintenance on the properties paid for, will only make this situation worse. We'll end up with British tenants being evicted, rents being forced up, and the already limited housing supply getting worse. The problem for the communities of places like Runcorn is that these houses of multiple occupancy often have 15 to 20 young men in them, and families living nearby have to put up with antisocial behaviour through the night, drug dealing, people coming and going, noise. I've seen CCTV throughout the campaign. I've heard the stories. People are frightened to go out. People certainly will not let their children play out on the pavements when they have these houses in their streets. We know that these HMOs are breeding grounds for organised crime gangs, whether that be drugs, whether that be people trafficking, or whether that be grooming gangs. Something recently downplayed by the Leader of the House. Sexual violence against women, abuse of women, the safety of women and children will be something that I will champion, not deny. My background in the justice system will also, I hope, give substance to my contributions on subjects close to my heart, like the current state of our prisons, the daily threat that our brave prison officers, men and women, face when they go to work. Just recently, again, another example in the news over the last couple of days about what they're facing. I will also be a strong voice against the prosecutions of our Northern Ireland veterans who were so brave on our behalf in the Troubles. I will be brave as they were for us, and I will stand up for what is right and fair. Turning to the constituency itself. It's a new constituency. It was formed in the boundary changes of last year by 5 other constituencies lending areas to its geography. Not only is it new, it's diverse. It's home to some of the wealthiest, to some of the poorest. It's home to a beautiful market town, vibrant town of Frodsham, to Runcorn Old Town, which is in decline and in desperate need of investment. It has beautiful leafy villages, and it has housing estates battling drug crime, battling antisocial behaviour. And I have lots of wonderful businesses in the constituency, ranging from the chemical industry, the farming industry, right through to the science park. So there's a lot of really good businesses in this constituency. But there are many challenges ahead. And some of the problems that I'm going to take on behalf of my constituents are things like the drastic shortage of housing, on things like the desperate need for investment and regeneration of the old town. The standard of education in the 5 secondary schools is at best average, at worst way below average. Somebody needs to highlight these issues. We have an incinerator that churns out toxic waste. An investigation into the health implications is currently ongoing. And then we have
the white elephant that is the net zero project, carbon capture, carbon storage, and an extensive solar panel farm right across the middle of this constituency. I will challenge the people who've put these policies in place. I will speak for the people who have so long lacked the representation they deserve. This constituency has huge potential. It has hard-working people that just want fairness, and I will be their voice. To conclude, I would like to thank the Honourable Member for Clacton for his vision, his commitment, and his conviction that has brought a new voice to this chamber. I will stand up for what is right. To all my colleagues in this room, you will find me fair, principled, and here to serve my constituents. Madam Deputy Speaker, I have been asked many times over the last 10 days whether I am overwhelmed by recent events, whether I am overwhelmed by being in this place. I am not overwhelmed. I am deeply respectful of this place. I am humbled by this place, but I am ready for this place. Thank you.
I call Chris Murray.
Thank you, Madam Deputy Speaker. And it's an honour to follow that eloquent and impassioned maiden speech by our new honourable member. I can tell we'll be hearing a lot more from her in this House. And while I'm sure her colleagues are pleased to have their number back up to 5, I think we can all understand her lucky number is 6. Can I draw the House's attention to my register of interests and the support provided to my office by the Refugee Migration Project? And I'd like to make a couple of points in relation to the amendments today, particularly drawing on the evidence we heard at the committee stage. The purpose of this legislation is to stop the small boat crossings in the Channel. They are too dangerous, too many vulnerable people die in the attempt, and they represent a lack of grip on the immigration system, because it should be the government who decides to come into this country, not people smugglers. It is clear the previous approach manifestly failed. That is because the Rwanda scheme means you can never reduce demand enough. As Dr. Walsh from the Migration Observatory told us in our evidence sessions, demand for crossing the Channel is essentially inelastic. You will never get enough to get it down. Deterrence alone, therefore, will not work. If you want proof, consider that of all those asylum seekers in the system, those who went to Rwanda represent 1/4,000th of 1%. So rather than tackle demand, we should tackle supply. We need to make it harder to get in boats, harder to organise crossings, disrupt the supply chain that drives this multi-million-pound industry, and seize the phones of those making the crossing. Let me briefly turn to new Clause 3 on safe routes. Let's be clear, there is absolutely a wider case for safe routes, and there is a national obligation to help where we can. Let us also be clear, safe routes already exist at significant scale. Some 500,000 people sought sanctuary in the UK through them over the last few years. And thirdly, we must be clear that given the vast numbers of people in the asylum system just now, no one can argue that Britain does not have enough refugees. But most importantly, safe routes, I would argue, fall into the same logical trap as the Rwanda scheme, in that they aim at reducing demand rather than tackling supply. Rwanda said, don't come because there's a tiny chance you'll be sent to Rwanda instead. Safe routes say, don't come because there's a tiny chance you can come through safe routes instead. Let's be clear, the purpose of this bill is to reduce channel crossings. There are good arguments for safe routes on many levels, but having worked on migration policy for 15 years before coming here, we have to recognise that they would not play a role in reducing cross-channel travel.
Carla Denyer.
Thank you, Madam Deputy Speaker. The Government's repeal of the Vile and Illegal Safety of Rwanda Act and large parts of the Illegal Migration Act 2023 are welcome. But the government must do more to repeal the underlying legal framework which continues to undermine the UK's ability to uphold the rule of law and human rights. The Illegal Migration Act simply does not belong on the statute book, and my preference would be to scrap the lot of it. My Amendment 35 at least seeks to restore judicial oversight on decisions about detention. The Immigration Law Practitioners Association points out that without my Amendment 35, a software engineer who overstayed her visa could be detained for longer than a suspected terrorist and with far less judicial oversight. Turning to my new Clause 38, I'm disappointed to see that the government has not used this bill to repeal the Nationality and Borders Act 2022, when it rightly opposed that legislation in its entirety on its second reading in this place. That act marked the UK's move away from upholding the 1951 Refugee Convention and instead denies the right to territorial asylum. Yet this Labour government has chosen to leave that act on the statute book, untouched by this bill. My new Clause 38 focuses on undoing the provisions that penalise and criminalise people who make unsafe journeys to the UK to seek sanctuary. It scraps the parts that create an unfair two-tier asylum system with differential treatment for different groups of people, a proposal so unworkable that the member for Newark had to pause it while in administration. Crucially, it scraps the law which criminalises people arriving in the UK without permission or the right paperwork with a penalty of up to 4 years in prison. This law is clearly contrary to Article 31(1) of the 1951 Refugee Convention, which provides immunity from penalties in recognition of the fact that refugees are often compelled to arrive without appropriate documents in order to access their human rights under that convention. And lastly, my new Clause 38 scraps sections 30 to 38 of the Nationality and Borders Act 2022, which sought to, I'll put it charitably, poorly reinterpret the Refugee Convention. Madam Deputy Speaker, through my amendment, I want to highlight that the government is leaving on the statute book measures that unjustly penalise and criminalise refugees for arriving irregularly when there are no safe and managed routes to travel here to claim asylum for the vast majority of people who might need and be eligible to do so. In the words of Worcestershire, no one puts their children in a boat unless the water is safer than the land. Madam Deputy Speaker, this government is clearly focused on appearing tough on immigration, and to do so, they brought in some of the previous government's cruel policies and introduced some of their own. As a Green...
Order. I call Bell Ribeiro-Addy.
Madam Deputy Speaker, I want to speak in particular in support of new Clause 37 in my name, but I want to begin by addressing the political theatre that often surrounds immigration. Politicians will constantly speak about immigration, spinning fear and suspicion, and then conveniently report back that immigration is the top concern for voters when it is not. Recent polls show that clearly immigration does not feature in the top concerns amongst those who were considering voting Labour but didn't. Instead, people are talking about tangible issues, the winter fuel allowance, the rising cost of living and the desperate need to fund our public services. But instead of dealing with these things, we choose to stoke division with sentiments about strangers. So I want to be crystal clear that immigration is not the crisis. What we're facing is the crisis of how we treat people, how we value rights and how we understand our responsibilities to one another. The focus seems always to be on small boat crossings, but irregular migration, people arriving by boats, accounts for just a fraction of nearly the 1 million people who came to this country. These I will not call illegal migrants because it's morally degrading, and asylum seekers actually have the right under international law to seek refuge. And if we want to resolve these issues, we need to start with safe and legal routes. It's regular migration that's actually soared since 2021, the Tories post-Brexit, and that's because the government's own policies created this situation. The points-based immigration system was always designed to encourage people to come here, and they have. So the issue is not migration itself, it's the exploitative business model behind it. And you know, it isn't about fairness, it always seems to come to profit, and it's the same logic, profits over people, that governs our asylum system. So look at the companies that are contracted to run immigration detention, like Serco, at my time, Mears, household names at Serco, all profiteering. They make millions off the back of vulnerable people, and we've seen reports into detainees abused, unsanitary conditions, and yet they continue to get millions of pounds in contracts. And while we're speaking about protection, I want to turn to children, specifically the children born here in the UK or who have lived here since they were young and have called no other place home, but yet are still denied British citizenship. And that's why I tabled New Clause 37 to address this. These children are not migrants. They are not migrants, but they are treated like second-class citizens, often not even knowing that they are officially not citizens until they try to apply for university or a job. And, you know, does that sound familiar? They suddenly find themselves locked out of everything through no fault of their own, a quiet scandal, just like the Windrush scandal. Lived here your whole lives, only to be told that you have no right to be here. And we promised never again. We said that we would learn lessons. But in 2025, we are charging British-born children £1,214 to register as citizens, when we know the administrative cost is only £372. These are children that we are charging for something that is their right. That's 215,000 children up to who are legally entitled to citizenship but are undocumented because of this exploitative fee. The fee waiver is not working, and you know, we're calling for fairness here, and at the very least, if a child is entitled to citizenship, they should be able to claim it without being priced out. No child should be punished for where their parents were born or how much money they have.
I call Pete Wishart.
Much, Madam Deputy Speaker, I rise to speak to my new clauses and amendments, and I beg to move new clause 3, which stands in my name. I was going to congratulate the honourable member for Runcorn in her maiden speech, but she seems to have joined her colleagues in the bar. I was going to say to her, she's achieved something quite notable, that she's actually been able to bring, and force this government to bring forward this immigration white paper as both of these parties try to outdo and triangulate the honourable members who are no longer behind me. And can I just say to them, probably more or less wasting their time, why would they go for one of the diet versions when they could have the full-fat honourable gentleman behind me? Yeah. Madam Deputy Speaker, I've spoken at every stage of this bill and spent 4 interminable weeks and countless hours on the Public Bill Committee. I wish I could say other than being with the Minister. Of course, it was a positive experience, but it was nothing other than a thoroughly frustrating, depressing and dispiriting one. I've been appalled at the emerging casual and callous way that the most wretched people in the world are now portrayed and demonised, and I fear what this House now has in store for them. I despair at the lack of empathy and humanity that's been shown to some of the most desperate people in the world, and I abhor this perception that essential human rights that have been considered a hindrance to be dispensed with in the even more pursuit of cruelty and disregard. I think that the House forgets these are real people fleeing conflict, oppression and unimaginable horror. Now, I rise to move my new clause 3 on safe routes because I believe this is the only way we could deal with them. What we have done just now is create a monopoly and an exclusive rights to the gangs which operate these crossings across the channel just now. There is no other way for asylum seekers to assert their asylum rights. Most of them, when they have the opportunity to assert these rights, actually have them granted, which makes a nonsense of the fact of illegal immigrants and asylum seekers. Instead of smashing gangs, what they are actually doing is giving them new opportunities and making their business model even more lucrative. And I want to pay tribute to all the agencies and support organisations which helped me with these amendments and the amendments throughout committee, who are now also in some sort of legal jeopardy because of some of the clauses and inclusions in this bill. Their opportunities to support the most desperate people in the world through advocacy, through looking after their rights, are now at risk because of some of the measures within these bills. But, Madam Deputy Speaker, I think that we're heading into a particularly dark place in some of the considerations around some of these issues. I'm impressed with some of the Labour speakers when they talk about immigration, and we have to be very careful how we handle this particular debate as we go forward. But I really fear just now. I listened to some of the language used by the Prime Minister this morning, and I was horrified by the way that he conjured up some of the language that we thought we had lost decades ago. And this is the type of territory that we venture into with very great sensitivity, and I'm afraid that the Prime Minister lost that there this afternoon. But I hope that we do get the opportunity to move these new clauses, secure these routes, and make sure we do everything we can for asylum seekers.
I call Joe White. Thank you, Madam Deputy Speaker. People started dying. People were screaming. It was very painful when someone is dying inside the water. The way they die, they cannot breathe. It is very difficult. I never thought I would experience such a thing. It is a harrowing experience I do not want to remember. I was holding on to what remained of the boat and people were screaming. It is something I will not forget. This is the witness testimony of Mohammed Omar when he spoke at the Cranston inquiry, which is investigating the UK's worst small boat disaster. On the 27th of November 2021, it's believed that 31 people lost their lives. Mohammed said he was told that 33 people were aboard the dinghy, but more people were added, including children. Those gang members whose sole focus on the billions that the horrific trade generates, who overload boats that are not fit to go into the ocean, who treat human life with no value, willing to put lives at risk for huge profits must experience the full arm of the law. This bill gives the Border Command the powers to do this, to pursue, arrest and prosecute those people. Breaking and destroying the gangs is critical to bringing an end to the small boat crossings. Mohammed's witness evidence underlines how important it is to achieve this. The bill not only gives the power and authority to work with our international partners to track down breaking up the gangs with the powers to seize and interrogate mobile phones and laptops to collect data and evidence, but the new amendment will bring in enhanced legal working checks, putting a stop to those delivery drivers bringing meals or parcels to our doorsteps who cannot speak a word of English and potentially using IDs borrowed or purchased from legitimate employees. I welcome the raids on businesses, the nail bars, the barbers, the restaurants employing illegal workers potentially in slave labour conditions. In January, there were 131 raids in my area in the Midlands, with 106 arrests. The amendment will mean that those arrested will now face fines of up to £50,000 per worker and prison sentences of up to 5 years. The French has said that people want to come to the UK because it's all so easy to be swept into the black economy and work illegally. The heavy disincentives of fines and prison sentences have the power to put a brake on the demand for the legal trafficking of people. I welcome this bill and as I said in February, crack on with the job, give us a running commentary of every success, publicise the return flights and the jailing of criminals, clear up the Conservatives' mess, secure our borders, close down the use of hotels and stop the small boats. Today is the next step forward.
Yeah. I call Esther McVeigh.
Thank you, Madam Deputy Speaker. I rise to speak in support of New Clause 14. This government came into power on the promise of smashing the gangs and cutting immigration numbers. What an empty, cynical slogan that turned out to be, and the exact opposite happened. The gangs were emboldened and they lost control of illegal immigration, up 31% since the election and up 35% since this year. So after the failure of smashing the gangs and the poor showing at the recent elections, the government's response is another gimmick, and that gimmick is the Border Security, Asylum and Immigration Bill. The bill is hollow. Its 5 core principles are a word salad of empty phrases, and the bill is a rehash of old ideas and contradictions. And what it lacks is a deterrent. In fact, the biggest mistake this Prime Minister has made in a strong field of contenders has been cancelling the Rwanda scheme. Even the National Crime Agency described it as a deterrent, and it was already starting to work. We were seeing those coming in by dinghy from France starting to head to Ireland and other countries. And without Rwanda or another third country, there is no way to remove any illegal immigrants who destroy their documents as they come to this country. And as a result of cancelling that deterrent, we have seen illegal migration soar. Now, some of this illegal migration will come down, immigration levels will come down, but as a result of the former Prime Minister, the MP for Richmond, what he did with his restrictions to stop dependents entering the country, and the bilateral deals he made, like the ones with Albania to deport criminals. So this government now says it's going to create a new legal framework for immigration judges to prevent illegal migrants and foreign criminals avoiding deportation by exploiting the ECHR Human Rights Act, Article 8. This is never going to happen by a human rights lawyer who leads a Labour Party or a Labour Party that champions the ECHR and the Human Rights Act. The reality is until this government gets ahead of the curve and gets a spine and takes the UK out of the ECHR and repeals the Human Rights Act, a Labour law introduced to cement the ECHR into British law, and reinstates the Rwanda scheme and radically clamps down on housing and benefits, I'm afraid immigrants will continue coming to the UK. The British people expect security and prosperity, not platitudes and broken promises. We in this House must act accordingly and vote in favour of new Clause 14, which would disapply the Human Rights Act.
I call Nadia Whittam.
Thank you, Madam Deputy Speaker. Vulnerable people are dying in the Channel and in our asylum system in record, horrifying numbers. Today, yet another person tragically died trying to reach our shores. The exact figures are murky, but from what we know, last year was the deadliest year ever for people seeking asylum in the UK. The UN estimates that 82 people, including at least 14 children, lost their lives in the Channel, but French frontline charities believe the fatality rate to be significantly higher. Meanwhile, Freedom of Information requests reveal that 51 people died in asylum accommodation, among them a 15-year-old boy and 2 babies. People are drowning while trying to reach safety, and once they arrive, they are dying by suicide, from infectious diseases and unknown causes, in poverty, in low-quality accommodation, or on the streets. Like the teenage victim of modern slavery who took his own life while terrified of deportation, or the father of one who died of diphtheria after being held in a government processing centre, or the 7-year-old girl crushed to death on an overcrowded boat. In several cases of deaths in asylum accommodation, there have been alleged lapses of safeguarding codes. These deaths are utterly unacceptable and often preventable, yet the Home Office keeps no official record. As such, we don't know how many lives are being lost. The government rightly wants to reduce deaths in the Channel. The starting point must be to know the numbers. My amendment, NC1, signed by 24 MPs, is a call for truth and transparency. It would mandate the Home Office to record and report statistics and information on the deaths of people in our asylum system who are meant to be in their care and those at our borders. This would provide opportunities for scrutiny and accountability, because no matter where they come from or how they got here, people deserve dignity. We must not allow them to die in silence, ignored and uncared for. So I urge the government to act. We need a new approach to refugees and asylum. We need to stand up to members opposite, scapegoating desperate people for the problems our communities are experiencing after 14 years of Conservative austerity, instead of parroting them. I'm glad that this bill repeals the Safety of Rwanda Act and much of the Illegal Migration Act, but we need to reverse all the dehumanising policies implemented by the last government, not just the ones covered by this bill. We need to expand safe and legal routes to the UK, including resettlement, family reunion, and piloting a refugee visa to travel, as proposed in a report by PCS and the Union and Care for Calais, the launch of which I was privileged to host here in Parliament. No longer must people seeking asylum fall through the cracks of a system which does not provide them with the care and safety they deserve. Let's ensure that every person who loses their life is counted, remembered and mourned, and that we do everything in our power to prevent anyone else dying because of this inhumane system.
Sir Christopher Charp.
Madam Deputy Speaker, may I speak briefly to new clause 39 in the name of my right honourable friend, the member for Gainsborough. He is unfortunately not able to present this argument himself today because he is actually attending a meeting of the Legal Affairs Committee of the Parliamentary Assembly of the Council of Europe, and he's asked me if I would speak briefly in support of this. And I hope that in doing so I'm going to be able to tempt or encourage the Minister to expand a bit more on whether the government thinks that this is rather a good way of trying to ensure that the worst abuses which we've seen in the court system are avoided in the future, because essentially my right honourable friend's amendment would give precedence to the non-refoulement arrangements in the Refugee Convention and in the UN Convention Against Torture, but they wouldn't allow the European Convention on Human Rights and the interpretation of the European Court of Human Rights to extend beyond those provisions. And I think that this is very important, because fundamental to English law is the principle of equity. And if people come here with clean hands and seek justice and our support, we should be very keen to encourage that. But if people come here and they abuse their hospitality or they've already committed offences, then we should get rid of them very quickly. And that at the moment is not very easy because of the way in which the courts are interpreting the European Convention on Human Rights. And my Right Honourable friend for Tatton referred briefly to a new clause 14. The problem that I've got with new clause 14, it doesn't actually go far enough, because it talks about getting rid of the or disapplying the Human Rights Act, but it only goes to talking about disapplying the interim arrangements for the European Convention on Human Rights. I think we need to go much further than that, and I'm slightly reluctant to be enthusiastic about it. But one provision I was very enthusiastic about and am enthusiastic about, and I'm disappointed that the official opposition are not going to be calling a division on it, and that's new clause 15. Because new clause 15, in the terms of the Shadow Home Secretary's explanatory statement, says this new clause will prevent a foreign national who is convicted of any offence from remaining in the UK, as well as anyone who has been charged with... Yes, I could wait. Yes.
Well, I very much agree with my right honourable friend. Does he not also recognise there is an issue of democracy here? Successive governments, successive ministers have said they want to toughen up the regime. And yet activist judges are undermining that, and that is a further reason for supporting the clauses that he is setting out.
Well, I agree with my right honourable friend, and if one wants a sort of current example, there was a headline in the Daily Telegraph on the 1st of May which said, "Migrants spared prison after punching a female officer." This was a fact. This was a court case in Poole, in Dorset, not far from my constituency. And this was a small boat migrant who repeatedly punched 2 female police officers, and he was spared jail. And this is completely laughable. And I've got the support of the David Sidgwick, the excellent Police and Crime Commissioner for Dorset, trying to take this issue further. But it brings the whole system into disrepute. The fact that people come here, they seek our help and assistance, and when they abuse the system, we are still indulging their presence. And I hope that the Minister will get much tougher on this. And sadly, the bill as drafted seems to be actually weakening the offence regime under the immigration law rather than strengthening it, which is what I think we should be doing.
I call Philp.
Thank you, Madam Deputy Speaker. I'm pleased to speak in support of the bill today because for far too long, criminal smuggling gangs have operated with virtual impunity, ruthlessly exploiting men, women and children and putting their lives at risk for profit. That's why I'm encouraged to see a government being honest with me and my constituents. No more gimmicks. No more wasting £700 million on unworkable and fantastical Rwanda schemes. Just giving our law enforcement bodies the tools and the resourcing they need to intervene earlier and act faster, with new offences to target those who supply or handle boat parts used in crossings, with up to 14 years behind bars for those guilty, seizing electronic devices like phones and laptops to help gather evidence and disrupt operations, and a new interim serious crime prevention order to allow immediate restrictions on travel, communications, finances, to stop criminals in their tracks before they escalate their activity. And it's also why I'm particularly pleased about the £150 million into the new Border Security Command and further National Crime Agency officers working across Europe, including, importantly, through Europol. It's not rocket science, but the National Crime Agency itself has said that these measures will give them what they need to disrupt smuggling networks and dismantle their business model. Just as importantly, this bill will put a stop to the party opposite's attempts to turn our backs on the world, as we saw recently with the 2 fantastic trade deals concluded recently with India and the US just last week. And that's a vital recognition that putting Britain back on the global stage and tackling the gang smuggling people into our country can go hand in hand. Now, crime doesn't respect borders, so it's quite right that we are prioritising strong international partners, and I would particularly like to welcome the new joint action plan with Germany through the Calais Group and the G7 and the alignment of efforts across Europe to shut down smuggling routes, seize key equipment and bring gang leaders to justice. New clauses 6 and 7 both set reasonable timelines for first-tier tribunal appeal determinations, important clarifications given the damage interminable proceedings and delays due to trust in our immigration system. These will cut the asylum backlog and drastically save money for taxpayers. And new clause 7 will, I hope, improve our approach regarding persons convicted of serious sexual offences, something I know my constituents have grave concerns about. So it's right that foreign nationals who commit sex offences should not be able to claim refugee status here in the UK. The UK is a welcoming and open nation, and we need a sensible, fair and caring immigration system to support our key industries. But I'm pleased that the government is making moves towards that, and I am pleased to support the bill tonight.
Nick Timothy.
Thank you, Madam Deputy Speaker. I want to go through the difference between what the government told the newspapers and the reality of this bill and the amendments that are presented today. Ministers said they would change indefinite leave to remain. The White Paper proposal today is weak, and the Home Secretary admitted it may not apply to immigrants already here. So it's no wonder that the government refuses to support new Clause 11, which would do the job for them. The visa crackdown on the nationalities, Pakistanis, Nigerians and Sri Lankans, we were told, blamed for asylum costs. The promise to kick out all foreign criminals, both were headlines with no credible policy presented to us today. The government promised action against the tens of thousands of people, maybe more, working illegally for delivery companies by abusing substitution clauses. So it is welcome that substitution clauses are being added to sections 15 to 24 of the Immigration, Asylum and Nationality Act. But what will be the operational reality? There are perhaps 1 million illegal immigrants in Britain, but only 366 fines were imposed for illegal working in the last quarter of last year. At least 100,000 people are trading identities online to work as substitutes. Before the local elections, the headline said foreign sex offenders will be banned from claiming asylum in the UK. And I suppose this is what Government New Clause 8 does. But what use is this if ministers don't give themselves legal powers to deport foreign sex offenders? The government is whipping its MPs to vote against New Clause 14, which does disapply the Human Rights Act and interim measures issued by the European Court of Human Rights in Strasbourg. Madam Deputy Speaker, today is, I'm afraid, just another stage in the cycle of political deceit. Now, I should say that my party has in the past been as culpable as the party opposite, and we must be honest about that. Immigration policy must be not just about who comes here, but about who we decide must leave. People here on time-limited visas must be told to go. People who refuse to accept our culture and way of life must leave, and people who have broken the law and those who take out less than they put in must be thrown out. We're going to need to ensure vast numbers of removals and deportations in the years ahead. And we need to remove the legal impediments in domestic law and in international conventions drafted in another age that stop us securing the border and saving our country. And we must be tough about who we allow to come here. We cannot afford to import more of the world's hatreds nor allow foreign conflicts to be fought out on our streets. We must accept that not every migrant is the same and not every culture is equal. 1 in 50 Albanians in Britain is in jail. 1 in 3 Pakistani and Bangladeshi heritage adults is economically inactive. 72% of Somalis live in social housing. We are a million miles away from doing what is necessary, and despite the rhetoric, this bill takes us even further backwards. Look past the words, and this country will see what this government is doing.
Jo Platt. Thank you, Madam Deputy Speaker, and I want to speak in support of the bill and the government's new clauses, as it is an issue that matters deeply. Because when we talk about immigration and border control, we're not just talking about policies made in Westminster. We're talking about real-life consequences on those seeking refuge. And this bill is a major step forward in building an immigration system that is both firm and fair, robust and compassionate. So since the general election, this government has already taken bold action. Over 24,000 people with no legal right to remain have been processed, the most in years. And in just 1 month, enforcement teams raided over 800 businesses, arresting more than 600 people for allowing illegal working practices, a 73% increase compared to the same period last year. But this is just not about numbers. It's about confronting a criminal underworld that preys on human suffering. People smuggling gangs are profiting from desperation. They are putting lives at risk in the Channel and undermining the values of fairness and order that we all believe in. And now with this bill, we can go even further with new clauses 6 and 7 and new clause 8. We are introducing real criminal penalties for those who supply boat parts, up to 14 years in prison. We're making it a crime to endanger life at sea during illegal crossings. And we are modernising how we process asylum claims, using AI to speed up decisions, banning sex offenders from ever claiming refugee status here, and putting tough restrictions on bogus immigration lawyers. But let me also be clear. Being tough does not mean being cruel. True compassion means creating a system that works for everyone. And that includes the people that are coming here, because there is nothing humane about placing vulnerable people from around the world into the most deprived communities in this country, with poor housing, overstretched services and no opportunity to rebuild their lives. And in Lee, we have seen this firsthand. So this doesn't relate to the bill, but I do need to mention it. Serco has acquired many properties in Lee and Atherton and around the greater Manchester area. Our town has lost its industry. We have fewer job opportunities and a housing crisis of our own, and yet we are being asked to carry a disproportionate burden simply because our homes are cheaper. So that isn't compassion, that's neglect. And for those being housed in failing conditions, no one benefits. Not the asylum seekers, not our local residents. This government is delivering real results for the first time, and this is what we need to see. We need to see a fairer system, one that protects lives, upholds the law and restores order without losing sight of basic human dignity.
Zoe Franklin.
Thank you, Madam Deputy Speaker. First of all, may I start by noting that I am the Vice Chair of the APPG for Refugees, and I rise to speak this evening in favour of new clause 21, which would allow asylum seekers the right to work after 3 months of waiting for a decision. A measure I back for 3 key reasons: common sense, economic rationale and human dignity. In my constituency of Guildford, I work closely with a charity called Big Leaf, an outstanding organisation supporting over 200 displaced young people. Through them, I met Mohi, a young woman who, on arriving in the UK, lived in a hotel consecutively for 20 months. Her husband had nursing experience and Mohi herself dreamed of becoming a nurse. She told me, "I want to give back to the country that has given me safety. We are here to be useful. We don't want to rely on benefits. We just want a normal life." Big Leaf, her peers, her mentors, her colleagues, her employers all recognised what she could become. Everyone saw her potential except the system. Today, she works as a healthcare assistant and this September is excited to begin training at University of Surrey to become a nurse. New clause 21 would have given Mohi, and so many like her, the chance to contribute, to grow and begin their lives in this country with dignity. Britain lags behind our international friends. Countries like Canada and Sweden allow asylum seekers to work within weeks. The Refugee Council and Lift the Ban Coalition estimate that the change made by New Clause 21 could generate over 100 million a year through tax revenue and savings. For a country that prides itself on sensibility, I have to question why, for 14 years, the Conservative government refused to see sense on this issue. We have the opportunity today to bring change, improve lives and unlock so much potential, both human and economic. And I urge colleagues... I will give way.
Thank you. I thank my honourable friend for giving way. In addition to the 3 fantastic reasons she gives for lifting the ban, it is also popular with the public. 80% of people polled back the right for asylum seekers to work. In addition to that, 45% of asylum seekers would be classified as critical workers. So does she agree that there's, in fact, 4 fantastic reasons why the government should lift the ban?
I absolutely agree with my honourable colleague, and I thank you for his intervention. And I will just end by saying I urge colleagues across this House to vote in favour of new Clause 21 to unlock all of these 4 reasons that between us we have stated. Thank you, Madam Deputy Speaker.
Tom Hayes.
Thank you, Madam Deputy Speaker. So late in the day, with so much said, I'm going to take the direction which is different to some of my colleagues. I want to talk about what border security means for us as a country. The playwright James Graham says, "Our country is only the story that we tell about ourselves." Well, with the Conservatives, we were told a story of hopelessness, despair and scapegoating. People were left to believe that we should be frightened by the challenges we face, frightened by our inability to meet them, frightened by the setbacks that we face and what they say about who we are and where we're going. And that's why it's so important for this Labour government to be correcting that narrative, getting a grip on our borders, closing asylum hotels, bringing the asylum bill down. These are the basics that people expect. These are what make people feel confident, not frightened, feel secure, not susceptible to those who on the opposite benches would peddle empty promises and ultimately let the British people down in the end. For me, no. For me, border security sits alongside fixing potholes, tackling graffiti and fly tipping, and stopping e-scooter and e-bike speeding. It's obviously more complicated than these. It involves a lot of international negotiation for one, but border security is security. It's vital for people's safety and pride. It underpins so much. If people cannot rely on the basics, they cannot begin to enjoy everything else that life has to offer. If people can't see pledges being kept, promises being delivered, things being improved where they live, they won't just lose trust, they will succumb to hopelessness. We must not allow the spirit of our people to break. We must get the basics right, and with this bill, we will do that. We will secure our borders with this bill and these amendments, new powers on seizing electronic devices, a new law to protect life at sea, a new statutory border security command, tougher action on foreign national sex offenders, ending asylum hotels that cost eye-watering sums. It's in our national interest to get our borders back under control against criminal smuggler gangs. Now, in order to understand the politics of where we are, I've been looking back over old debates, and the Conservative members opposite may enjoy what I'm about to say. With our policies and our politics on border security, as with much else, I feel like we could benefit from listening to a question that was put by the first Earl of Stockton in his maiden speech in the other place in 1984. Do we just slowly, majestically sink like a great ship, or shall we make a new, determined, united effort so historians of the future will not describe the decline and fall of Britain, but the beginning of a new and glorious renaissance? As the Member of Parliament for Bournemouth East, I want to work with all in this place who share the former Conservative Prime Minister's moderation and determination to have a united effort to bring about a better Britain, and that involves fixing the basics like border security. After all, it would be an absurdity for small boats to sink a ship.
Madam Deputy Speaker, the trafficking gangs that profit from the most vulnerable refugees do not care if those on those boats live or die, and it is obvious that we all want to see the end of this horrendous crime. But for those who travel, they are not bad people, they are desperate people. And it is understandable that communities who see groups of mainly young men, economically inactive, will be frustrated and angry. But these asylum seekers are not responsible for people not getting a doctor's appointment. It is the people who traffic them. When I was the leader of BCP Council, I backed the Lift the Ban coalition, and I met an inspiring young man from Cameroon who had arrived here legitimately on a student visa, and whilst here his village was torched and his uncle killed. He could not return home, and so he claimed asylum from where he was in the Midlands. He was immediately relocated to a hotel in Bournemouth and refused the ability to work, something he had done legitimately right up to that point. Letting him work would allow him to contribute to our community, not be a great drain on it. I also want to talk to the Liberal Democrat new clauses 24 and 33 relating to our work with international partners. Madam Deputy Speaker, as a member of the Armed Forces Parliamentary Scheme, I recently learned more about UNCLOS, the International Law of the Seas. Article 99 covers the prohibition of the transport of slaves, but it does not cover human trafficking. And around the world, our international partnerships are being hamstrung as a result. And I would urge the Minister to look to see how we could use the Interpol as a route towards developing UNCLOS further. Finally, Madam Deputy Speaker, I want to speak against New Clause 16, increasing the minimum income for a spousal visa to $38,000. This would mean the average police officer, research scientist or nurse outside of London in places like Mid Dorset and Northport would not be able to get a visa for their spouse. I was pleased the government paused the proposal, leaving the threshold at $29,000, as I'm concerned we could see a brain drain among many British professionals who would choose to leave the UK for their partners' home countries where they would be welcome. And I want to speak in particular for armed forces personnel that I've met, both in the constituency and through AFPS, in particular those coming from Commonwealth countries. They have answered our call to fight for our country, but they are forced to leave their spouses behind, as the lower threshold provided for them only applies after an extended period of service. Pushing that threshold up to 38,000 would take reunification out of their reach too. The current threshold ensures that families who can support themselves can stay together, and I would urge the government to leave it where it is. Madam.
Thank you, Madam Deputy Speaker. Let me begin by saying that we can all agree upon that immigration must be managed. The public rightly expects a fair, firm and functional system, but control cannot come at the cost of compassion. So let me be clear, immigrants cannot be viewed through the lens of fear. Parliamentarians on all sides must choose their words carefully. We are responsible for ensuring our rhetoric does not incite attacks, fear, division, or even lead to violence. It is not enough to say we denounce hate. We must also refrain from language that fuels it. And the terms like islands of strangers simply do not help. Too often we hear suggestions, explicitly or implicitly, that immigrants are to blame for everything that is wrong in our country. Let us be honest with the public. It is not the immigrants who have polluted our rivers or our seas with sewage. It is not our immigrants who set sky-high rail fares while slashing routes. It is not our immigrants who have hollowed out our NHS, cut GP services or closed libraries. And it is not immigrants who have overseen 40 years of economic stagnation, rising rents and growing inequality. There are indeed some aspects of this bill that I can support. Abolishing the ridiculous Rwanda bill is for one, but there are more shortcomings, especially in relation to the lack of help for victims of human trafficking, which is why I rise to support some amendments to the bill. I am calling on members across this House to support New Clause 27 to ensure proper age assessments are conducted by trained, independent social workers and not through rush visual judgments or flawed, impersonal scientific tests. Furthermore, in the shadow of our immigration debate, children are being exploited. They are the victims of modern slave trade run by some smugglers and traffickers who prey on desperation. Children are coerced into roles that put their lives and the lives of others at risk. These are not isolated cases. Over 4,000 unaccompanied children claimed asylum in the UK last year alone. The system must recognise the unique vulnerability of children and treat them as such. They are not as suspects, not as statistics, but as they are, children. So while the government's intent to address the asylum appeals backlog is also laudable, proposals like New Clause 6 and 7 to impose arbitrary deadlines of 24 weeks without sufficient resources or legal safeguards are not the answer. Justice rushed is justice denied. Finally, by taking on the narrative of the right wing, by mimicking their talking points and rhetoric, we are not neutralising the threat of extremism. We are feeding it. We will only push Reform UK and others even further to the right, emboldening them to say things we have made appear acceptable. So I ask the government to stand its ground. When will we choose principles over polling? When will we remember that leadership means bringing people together, not chasing after the loudest voices in the room? Let us reject the politics of scapegoating and lead with integrity, facts and humanity. Our country deserves nothing less.
Caroline Borden. Thank you, Madam Deputy Speaker, and I would like to focus particularly on New Clause 21. We can all see that the asylum system is broken, it's expensive, and the horror of people arriving in a desperate state on small boats is causing division and anger across our country. But turning to a populist party which throws out sound bites that appeal to many but fall apart at the first hint of real scrutiny is not the answer. So how do we address this problem? Firstly, we need to dial down the volume and divisiveness in this debate and talk about these people as humans, not numbers. We need to open up safe and legal routes for people who are genuinely fleeing war, persecution and conflict. We need to assess their asylum claims quickly and efficiently, and then help them into the workforce so they can start earning money, supporting themselves, contributing to the economy, and just as importantly, start integrating properly into our society. The Honourable Member for Clacton said on Radio 4 this weekend that his party chairman, the child of immigrants from Sri Lanka, was intensely patriotic. The whole point of coming to a country is that you adopt it, he said. And that is exactly what asylum seekers will do when given refuge by a country that offers them safety. We have seen it since time began. Indeed, many in this House are the children of immigrants who have given back enthusiastically to a country that welcomed them. The asylum backlog stood at 91,000 at the end of 2024. While they wait, asylum seekers are trapped in limbo, unable to work or rebuild their lives, and forced to depend on government funds. This benefits no one. The Liberal Democrats' new Clause 21 would lift these restrictions on asylum seekers engaging in employment, which would help manage the cost of asylum, benefit the UK economy and help them integrate. Evidence from the Refugee Council shows that in the medium to long term, refugees in the UK make a net positive fiscal contribution. Initially, they rely more on public services, but within 5 to 10 years, their tax contributions exceed their cost to the state. After 5 years, 60 to 70% are employed, approaching national averages for employment rates. And a study by the Centre for Entrepreneurs shows that 1 in 7 UK companies is founded by a migrant. 17% of non-UK nationals have launched businesses, compared to just 10% of UK-born individuals. The reality is that we have an ageing population, more people than ever over 85 who depend on services. We have fewer people paying tax, working, providing services, and more who have greater needs, particularly in health and care. The Chief Operations Officer of Care Your Way Franchising told me that we are both baffled and deeply concerned by the government's decision to revoke the visa route for social care workers. It is harrowing to witness such a critical sector continuously overlooked. This change will without doubt have a tangible and far-reaching impact. For many, this decision will not only reduce capacity, it may very well close doors. The Liberal Democrats are pushing for more safe and legal routes for refugees, which we know will be crucial to help stop these dangerous channel crossings.
Order. Iqbal Mohammed.
Thank you, Madam Deputy Speaker. The UK immigration system is in shambles. There's no secret after the debacle of the last government with the proposed Rwanda scheme, the controversial refugee barges, the Illegal Immigration Act to stop boat crossings, and the hostile environment that put immigration enforcement at the responsibility of nurses, doctors, teachers and public service workers. I think we all agree that any step towards fixing this mess is a step in the right direction, and this bill does deserve credit for repealing certain measures proposed by the last government. However, it needs to go further, and it still has substantial issues that worryingly criminalise vulnerable families fleeing hardship and fail to adequately protect victims of trafficking. Madam Deputy Speaker, let's talk about the most pressing failure of this bill: the complete lack of a clear, humane strategy for safe and legal routes. The truth is this: if you do not give people fleeing war, persecution or trafficking a safe way out, they will find a dangerous one. And we have seen the consequences: families risking everything, children arriving on our shores, and asylum system buckling under the weight of its own humanity. Yet this bill in its current state offers no plan, no route for how the UK will open legal doors instead of forcing people to scale fences. That's why I supported new Clause 3, which would require the government to do what has long been overdue and publish a strategy on how it will establish safe routes to the UK. We need safe routes not because it's morally right, but because it works. Moving on to deaths of asylum seekers. More than 10 people have already died this year trying to reach the UK in small boats, and last year over 80 people have died trying to reach our shores. That is why I also supported new Clause 1 to shine a light on the human cost of this broken system. Right now, the government doesn't have a system to ensure a full record of deaths is published. People die in asylum accommodation, people die while waiting for decisions. Also, over 450 children went missing between 2021 and 2024, and in 2024 over 100 were still unaccounted for. So, the immigration and asylum legislation is not just about fixing systems, it has a profound and real impact on people's lives. Therefore, it is crucial that the provisions within this legislation are compassionate and prioritise the needs of the vulnerable communities and the very people who suffer the most within these systems. Thank you.
we have no more further speakers, so then we go straight to the Minister Eagle. Forgive me, I thought we had another person bobbing, but they no longer seem to be in the chamber. So you get the lucky extra few minutes. Minister Eagle for wind-ups.
Thank you very much, Madam Deputy Speaker, and it's a pleasure to rise after what has been a very full debate with people having to put quite complex points in short amounts of time to fit in, and I'd certainly like to congratulate everybody for the points that they've made, and also try to deal with some of them in the time I have left as much as possible. Not sure how much time I have left, given the sudden. Okay, so I'd like to thank all those on the Labour side who've made their contributions. The Honourable Member for Liverpool Riverside, the Honourable Member for Folkestone and Hythe, the Honourable Member for Walthamstow, the Honourable Member for Sheffield, Hallam, Edinburgh East and Musselburgh, Clapham and Brixton, Hill, Basset Law, Nottingham East, Bolton West, Lee, and also Lee and Atherton. I think the Honourable, the Lib Dem benches really have particularly concentrated on the issues in safe and legal routes and the ability to work. I think the Honourable Member for Perth and Kinrossshire, I was disappointed, was worried that he'd had such a difficult time in committee. I thought we were having quite a reasonable time, but he's extremely downbeat about it. And I must try more on another occasion. Obviously, I'd also like to welcome the maiden speech from the Honourable Lady, the Member for Runcorn and Helsby, which we all listened to in the traditional silence. Congratulate her on that, welcome her to the House, and wonder if Reform are practising the principle of one in, one out, or perhaps one out, one in, but it's a pleasure to welcome her to the House. The Honourable Member from the front bench, the Honourable Member for Croydon South, produced a flurry of amendments and new clauses demanding that we do a whole range of things that he didn't do when he had the chance to, as not only as a Home Office Minister, but that they didn't do when they had the chance in 14 years. And I have to keep saying this, but we did inherit a system that was in the most incredibly difficult mess, with huge backlogs. He says we made it worse, but by beginning actually to process claims, that by definition creates a backlog of those who've been refused. So by trying to get the system working again, what happens, you get a backlog of appeals, because people who are refused asylum generally appeal, and therefore your backlog, as the Honourable Gentleman knows from his time in the Home Office, reappears in the appeal system, which is why we have the new clauses on attempting to get a kind of timeline for dealing with them. But I want to concentrate particularly on some of the things I know there'll be votes on tonight. Firstly, I want to deal, if possible, with on safe and legal routes, new clause 3. Our approach is to resettle refugees identified by the UNHCR who would benefit most from resettlement to the UK. Alongside this, we have bespoke routes to sanctuary for those from Ukraine, Afghanistan and Hong Kong, and it's important that safe and legal routes are sustainable, well managed and in line with the UK's capacity to welcome, accommodate and integrate refugees. Part of the difficulty that we have at the moment is the legacy we had from the party opposite of huge quadrupling of net migration and the issues around having to assimilate all of those in the huge unplanned way in which they delivered it. I want to talk about New Clause 37, the Honourable Member for Clapham and Brixton Hill. We recognise her campaigning on this issue over the last 5 years. We also recognise that there's been an unfair burden for some families with rights to citizenship by the system as it is, and I can confirm that the work referenced in the white paper on page 76, I think it is, right at the end of the white paper, will look at tackling the financial barriers that she highlighted in her speech, and I would urge her to work with us on how we move forward and to withdraw her amendment today. The opposition New Clause 14. Let me be clear that this government is fully committed to the protection of human rights both at home and abroad. As the Prime Minister has made clear, the United Kingdom is unequivocally committed to the European Convention on Human Rights, and it's worth noting that many of the legal obligations provided for in the European Convention are also found in other international agreements to which the UK is a party. Very quickly, because I have a lot of points and not much.
Just set out once again, as the Prime Minister did earlier today, her steadfast commitment to the ECHR. But does she not accept that that makes the legislation not watertight, and we will continue to see those who have committed serious criminality able to stay in the United Kingdom because of the ECHR?
We have new clause 8, which will deny those who commit sexual offences refugee status. And we also have the work that's being announced on narrowing Article 8, which will allow Parliament to give more choice to the more direction to the judges about how these rules ought to be interpreted. The immigration rules reflect the requirement of the ECHR, generally including the qualified nature of Article 8, setting requirements which properly balance the individual right to respect for family and private life with public interest in safeguarding the economic well-being of the UK by controlling immigration. I'll give way very quickly.
I thank the Minister for giving way. She mentioned the provision to prevent certain sex offenders from claiming asylum. While that is a welcome step, what will of course happen in practice is the sex offender will simply make a claim under ECHR Article 3 instead. I've seen dozens and dozens of cases like that, and that is precisely why we need to disapply the Human Rights Act from all immigration matters. Otherwise, there'll just be a huge loophole, as my right honourable friend just pointed out.
Well, if we disapply the Human Rights Act, then people would just go to the ECHR anyway, and a lot of these cases would end up in Strasbourg, which would take even longer. I think also disapplying the Human Rights Act also means that other countries cross-border who we have to work with and collaborate with to try to deal with cross-border people smuggling won't work with us. The party opposite had many huge rows with people and went around the world making it look like they didn't believe in the rule of law. Well, actually, this government believes in the rule of law and will carry on upholding the rule of law. That is one of the things that we regard as an important part of the value system that we have in this country. On New Clause 18, the cap on non-visitor visas, as always, the party opposite have talked a good talk when they're now safely in opposition, whilst not delivering it when they were in government. They promised time after time after time to reduce net migration down to the tens of thousands. They did it in manifestos, they did it in all of the different manifestations, many manifestations of Conservative governments that we saw plough through the House, especially in the last 4 years. And what did they do? They quadrupled the levels of net migration. So we don't need a cap. We need to get migration down, fundamentally lower than it is now, to make the system fair and effective. And in order to do that, we have published a white paper today. We have further measures in this bill, and we will be coming back to this issue to ensure that we can deliver, unlike the party opposite. Now, yes.
Minister for giving way, and I thank her for her early mention of my amendment and her commitment to end the financial burden that is coming up on young children in particular and their families who have a right to citizenship. I just wanted to ask what further work will be done in terms of consulting with people like the campaigns Citizens UK, Lambeth Citizens and the PRBC. Those are the types of campaigns that have been working on this particular issue. And I know obviously the white paper covers a range of issues, but I just want to understand what consultation will be done with those organisations to make sure we get to where we need to be, which is a situation where children are not being priced out of citizenship.
Minister.
My honourable friend, the Member for Citizenship and Migration, has just made it clear to me from the front bench as the honourable lady was speaking that she's very happy to consult and meet with all of these people. We want people to contribute to the consultation so that we can get this right, and I hope that in the light of that she will withdraw her amendment. I wanted to deal with the right to work in the very brief time that I have left. The Lib Dem bench has talked particularly about this, and it is an issue about balance. We know at the moment that if one's asylum claim is delayed for 12 months, you have the right to work in particular shortage areas. Our way of dealing with this is to get the system to work more quickly so that we don't have people languishing for very many years in limbo, and that is what we are aiming to do. We are worried that if right to work comes in after 3 months, that will be too much of a pull factor and get around some of the issues with work visas, and we have to have a system that people apply to properly rather than can get around by coming in by irregular routes. So that is the issue. I appreciate what members opposite are trying to achieve, but we just have a slight difference of approach on that. But clearly we will carry on having these debates. Madam Deputy Speaker, I commend all of this part of the bill and the report stage of the bill to the House.
Order, order. Under the order of the House of the 10th of February, I must now put the questions necessary to bring proceedings on the consideration to a conclusion. The question is that the Government new clause 5 be added to the bill. As many of that opinion say aye. Aye. On the contrary, no. The ayes have it. The ayes have it. That's what I said. Read it a second time. Oh, of course, I'll do the first one. The question is that, forgive me, the question is that new clause 5 be read a second time. As many of that opinion say aye. Aye. On the contrary, no. The ayes have it. The ayes have it. And I am now moving on to... The question is that new clause 5 be added to the bill. As many of that opinion say aye. Aye. On the contrary, no. The ayes have it. The ayes have it. And now we are officially moving on. We come to Government new clause 6 to 8. I call the Minister to move new clauses 6 to 8 formally.
Move formally.
The question is that new clause 6 to 8 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. New clause 3 has been selected for separate decision. I call Pete Wishart to move new clause 3 formally.
Move formally, Madam Deputy Speaker.
The question is that new clause 3 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. No. The question is, as on the order papers, may that opinion say aye? Aye. Of the contrary, no? No. The tellers for the ayes are Kirsty Blackman and Ben Lake, and tellers for the noes are Keir Mather and Christian Wakeford. Order.
The ayes to the right, 90. The noes to the left, 318.
The ayes to the right, 90. The noes to the left, 318. So the noes have it, unlock. New clause 14 has been selected for separate decision. I call Chris Philp to move new clause 14 formally.
Move formally.
The question is that new clause 14 be added to the bill. As many of that opinion say aye.
Aye!
No?
No!
Colleagues should be seated at this point. Colleagues should be not wandering around the chamber looking on their phones. They should be seated at this point. The question is, as on the order paper, as many that opinion say aye.
Aye.
Of the contrary, no.
No.
Tell us for the ayes are Katie Lamb and Richard Holden. Tell us for the noes are Keir Mason and Christian Wakeford. Order, order.
The ayes to the right, 98. The noes to the left, 402.
The ayes to the right, 98. The noes to the left, 402. So the noes have it, unlock. New clause 18 has been selected for separate decision. I call Chris Philp to move new clause 18 formally.
Move formally.
The question is that new clause 18 be added to the bill. As many as that please say aye. Aye. Contrary, no. No. Bernard, go. The question, as is on the order paper, has made that opinion say aye. Aye. Contrary, no. No. The tellers for the ayes are Katie Lamb and Richard Holden. The tellers for the noes are Keir Mather and Christian Wakeford. Order, order.
The eyes to the right, 94. The nose to the left, 350.
The eyes to the right, 94. The nose to the left, 315. So the nose have it, unlock. It has been brought to my attention that not all the division bells are working. We are trying to rectify that as soon as possible. I will urge colleagues to remain close to the chamber and the estate and to keep their eyes on the monitors as well. New clause 21 has been selected for separate decision. I call Lisa Smart to move new clause 21 formally.
Move formally.
The question is that new clause 21 be added to the bill. As many of our opinions say aye. Aye. On the contrary, no. No. Head lobby. Alison, Sir John, Ali, seated. Colleagues should be seated. Seated. The question is, as on the order paper, as many of that opinion say aye. Aye. On the contrary, no. No. Tellers for the ayes are Tom Morrison and Bobby Dean, and tellers for the noes are Keir Maker and Christian Wakeford.
Order.
The ayes to the right, 87. The noes to the left, 404.
We won it.
Yes.
The ayes to the right, 87. The noes to the left, 404. The noes have it. The noes have it. Unlock.
So you do need us.
New clause 37 has been selected for separate decision. I call Bell Ribeiro-Addy to move new clause 37 formally.
Withdraw.
New clause 37 withdrawn. I call the Minister to move amendments 6 to 29 formally. The question is that the Government Amendment 6 to 29 be added, to be made. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. The ayes have it. Consideration completed third reading.
Now.
Minister to move third reading.
Thank you, Madam Deputy Speaker. This bill restores order to an asylum system which was left in chaos by the party opposite. It puts an end to the failed gimmicks and the unworkable mess that they bequeathed us. It repeals in full the Safety of Rwanda Act. It repeals most of the unworkable Illegal Migration Act, which trapped asylum seekers in limbo as asylum backlogs soared and the taxpayer picked up a spiralling bill. This government is clearing up the mess that the party opposite left us, and the bill before the House will help us to succeed. It will assist in securing our borders by dealing with the soaring backlogs. It gives counter-terror-style powers to law enforcement agencies, equipping them to go after the people-smuggling gangs who are making millions out of exploiting people's misery. The bill introduces new powers to seize electronic devices and disrupt the activities of the people smugglers, new offences against gangs selling or handling small boat parts for use in the Channel, new powers around serious crime prevention orders targeting individuals involved in organised immigration crime, a new law protecting lives at sea, making it an offence to endanger another life during small boat crossings, a new statutory footing for the Border Security Commander, new and improved data sharing between government agencies such as HMRC and DVLA law enforcement to detect organised immigration crime. This bill introduces a statutory timeline for appeals decisions, a major modernisation of the powers of the Immigration Services Commissioner. It ensures that those who commit certain sexual offences will be denied protection under the Refugee Convention, and contains a long overdue extension of the right to work checks for casual and temporary workers in the gig economy. So why on earth, Madam Deputy Speaker, is the party opposite going to be voting against it tonight? People smuggling is a complex and multifaceted problem. There are no quick or easy solutions to prevent it. Anyone who claims that there are easy answers is a snake oil salesman. But it is possible, Madam Deputy Speaker, to identify, disrupt and dismantle the criminal gangs and strengthen the security of our borders with international diplomacy and operational cooperation. This bill will help us do just that, and I commend it to the House.
The question is the bill be now read. A second time, the Shadow Minister has a minute or two.
Well, thank you, Madam Deputy Speaker, for this unexpected opportunity. The reason that we on this side of the House will vote against this bill is because it does nothing to restore control of our country's borders. It repeals the legislative basis for a removals deterrent which is needed to stop people crossing the English Channel. The fact the Labour government cancelled that deterrent before it started is why illegal crossings have gone up by 29% since the last election, and it's why this year has been the worst in history for illegal crossings of the English Channel. This bill weakens border controls. It removes the powers the government could otherwise exercise to control those borders. They are failing, and this bill will do nothing to restore control of our borders.
The question is that the bill be now read a third time. As many of that opinion say aye? Aye! Contrary, no? No! Colleagues should be seated. It's surprising I have to do this at every division. The question is, as on the order papers, may in that opinion say aye? Aye. Of the contrary, no? No! Well, aye. Tell us for the ayes are Keir Mather and Christian. Wait for the tellers for the noes are Richard Holden and Katie Lamb. Yay. Order.
The ayes to the right, 316. The noes to the left, 95.
The ayes to the right, 316. The noes to the left, 95. So the ayes have it, unlock.